Where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Well, hello, everybody. Happy Tuesday. Boy, oh boy, do we have a lot to talk about. I was going to go live earlier, but as I'm sure you guys know, the day has been filled with lives discussing this. So as much as I want to go through like every detail of it, I probably will anyway. But I know most of you guys have probably heard a lot of what we're going to talk about today. So let's first discuss the fact that many of you guys have messaged me and let me know that some of my videos are missing. And yes, they are. I did have a copyright claim filed from our favorite duo podcasters who feel that they own the copyright to all of what I've done. Not all of them were copywritten. I did remove the other ones. I have all of them downloaded. So as soon as the YouTube world decides what they want to do, whether they're going to give let me keep my copyright strike, I guess, if that's what they're going to do. But I have filed an appeal with YouTube, and from everything that I have researched in the law, once again, there shouldn't be any reason that I don't get them back. And once they are back, I will re-upload all of the reenactments of the interviews. So just FYI, you'll see that some have been removed by me and some have been removed by them. But have no fear. I am not worried about it. This is, once again, like I said, they really like to waste people's time. It is, yeah, this will be the second time. I know. It is what it is. Once again, it's just literally, it's just time consuming. So I'll just do what I have to do to get it fixed and we'll move on with our life. There is a couple new interviews that we need to discuss. I don't know if we'll have time to do that tonight. I wanted to wait. The reason I'm going later tonight is because I know that everybody was live all throughout the day. So I was like, you know what? Let's listen to everything and then we'll come over here and we'll wrap it all up together and hang out for the rest of the evening and talk about whatever the hell we want to talk about. Yes, it's satire, SNL style skits. The thing is, it just hurts their feel bads. So, you know, whatever. I don't really give a fuck. So I don't really care about those people in the slightest. But it is what it is. So once again, just a waste of my time. But I will keep you guys posted on that, or you guys will just see that like I said, I have them all downloaded. I will just re-upload them all to the channel once that is all taken care of. So Nick, Mr. McClelland, has done an interview with the news, with the mainstream media, with his desk, with his big ass desk. We're probably going to touch on that tomorrow. And no, I have none of them up. None of them are up right now, Australia. None of them. Fighting for the case. Thank you, Andrew. Yes. After dinner. Did you eat dinner? Is your dad? Well, talk to your dad, please. I'm live. He's going to take care of your dinner for you, and then you can. There is no ice cream cones, though. Remember, you ate the last one last night. You could have, after you eat dinner, you could have Reese's peanut butter eggs.
What can I have right now?
You can wait for your dad and talk to him about dinner. Thank you. Poor guy, it's always so hungry. Acts like he never gets fed. He does nothing but eat all day. Oh, she did not like the pig roast title. No, she did not. That other one over there did not like your pig roast. So it is what it is. No, I gotta respond. Yeah, I know. The reason they listed is they didn't like the things I said and it wasn't considered commentary. That's the thing. It is all considered commentary. It is all so like, yeah, for the reenactments. What they don't want is anybody listening to the interviews anywhere else. So even if you're so unless you share their narrative, which obviously I don't, I even if I shared their narrative, I don't fucking like those people. So there's very few people I can say that about in this YouTube community, and there's just there are two of them I don't fucking like. So it is what it is. So that's a number one issue. And number two is it takes money out of their pocket if people aren't listening to them. Well, here's the thing: is most of the people who are listening to the reenactments don't listen to them anyway, so they're not losing a fucking dime because most people aren't going to listen to those two regardless, like me. So you're not losing any money because I'm not listening to your shit regardless. But it is what it is. So we got a big day. Big day. We had the motion to correct error. Lots and lots of documents to go over. Let me say hi to you guys really quick first, actually. So, Christine, I actually came over later because my stream ended late, and then I came over to your stream, but you were already done. So happy belated birthday. I am sorry that I missed it live. I did tell everybody to go watch the replay. So, yeah. Sleuthy, are you coming up or no? Are you too busy? Yeah, fuck that. Only because you didn't do your reenactment yet. I know. Yeah, I even after the first copyright strike, I gave them the benefit of the doubt, and then after the gaslighting of, oh my gosh, anybody who thinks that the trial is not fair, and that we're gonna read private messages of everybody else, and like that's okay. Like you don't think that those are copywritten by anybody, but you think it's okay to just read through those. Yeah, no, you're just shady fucking people, and that's where I'm at with it. So like I said, I could give a fuck, but I'm not gonna waste my whole night talking about idiots. We could be here all night, but no. So since that time, I'm like, you know what? Nope. All done. Carrie, 10 months, baby. Damn, it's been 10 months. And she gifted some memberships. Thank you. Welcome to the new members. What's up, Andy? After the doctor said RA wasn't tortured, he got a report to the Nevada Board of Psychologists. He got reported to the Nevada Board of Psychologists. Oh, I'm late, starting from the beginning. Oh, you haven't done anything yet. So you're good, Fiend, if you just stay here. What's up, Ramblin'? Hi, Indiana girl. What's up, True Crime Addiction? I'm counting on you to explain what happened today. Oh, shit. Don't pressure me. Don't put any... I guess I have big shoulders. I can handle it. I can't after you get started. Okay. What's up, Joanna? Hi, Lindsay. Hi, Christine. Other Christine and Christine. I guess that's a lot of Christines today. What's up, Chelsea? Hi, Sally. Susie Q. Just Deb. Hey, Nancy. What's up, woman? Let's go. That's what my son says when he's playing. My 16-year-old, we hear him in his room playing video games. He's just like, let's go. So we make fun of him all the time, and he's just like, you're dumb. Yeah, you can just go ahead. Well, so what they, like I said, I don't want to do this all night, but what they're essentially saying is that the entire time I was live, I was showing their video or airing their copyrighted material, which is just untrue. So, but it is what it is. What's up, CT girl? Ha, Sleuthy.
It's snowing again.
Do you want my video again?
No, but you know what? I saw like videos and stuff today of snow in Florida, like a good bit of snow, and I was like, oh my God, nowhere is safe. Where do I go? I was really considering moving back to Florida.
There's no snow here, honey.
Yeah, but my brother lives there with the Marines, and he's leaving. He's been there like a year, and he's like, I'm over it. He's coming back this way.
Michael Osbrooks, 0 degrees here. It's 0.
It's negative here.
Does that mean it's like no degrees? Like there's no temperature? Like, you know what I mean? Like I always wondered that. Like 0 is 0. Like there means there's no temperature. There's nothing.
All I know is my freezer is set to 0 degrees, and it's colder outside than it is in my freezer.
Yeah, no, I got nothing. I got nothing for you. It's nice. It's not. I'm wearing shorts right now, Sleuthy.
I'm so happy for you, Teresa. He's home from school again tomorrow. Fuck.
I'm so sorry. I'm so sorry that that's happening.
Oh, it could be worse. It could be -18, I guess. But regardless,
Regardless,
like,
there's still no there's no school.
when are they going back to
He's
school,
gonna be going
Megan?
back. He's gonna be in this grade until like November of this year.
They're going to go back, and then they're going to be like, it's summer break. And then I don't know what I'll do. People forget I got to work. I got to work all day. First of all, I will say I'm grateful that I do work at the house, because otherwise, like, I don't know how people who don't work at the house are doing that. Like, I don't have anybody here to stay home with my child if he has a snow day. So at least I'm not having to take off work. I don't know many workplaces that would put up with this. But
Well, I mean, are they not like? Are people still able to get to work? I mean, that's kind of like a big thing out there too. Is if they can't get to school, they can't normally get to work, right? Like, that means that shit's not.
well, but I work for doctors. So, like, if I was having to go in, that wouldn't really apply to me. If they
Like I
don't have
said,
a scribe, they won't work. Like, they can't. They don't know how to do their own documentation anymore.
yeah, my son's doctor's like that. She's like, "Am I scribe this year?" And I'm like, "Do you not know how to take notes anymore?"
You
Michael
know,
said everyone's been reading the whole thing, and maybe we should do the too long didn't read. Well, I'm just going to kind of skip around and just tell them everything that was filed, and then we're going to read through like the core of the matter and look at the stuff. I figure that's kind of better than.
yes, Carrie. I'm just
No, so,
curious. I'm super curious your thoughts on all of this.
so I've peeked at some things. I had so the 24 pager I have not read. So that's going to be
Oh,
totally a blind reaction to what we're doing here. I peeked at some of the stuff and just got everything in order. And then I have, like, Michael had posted a couple of the videos, and so I have those. So I peeked at like some of the exhibits.
mm-hmm.
But I purposely did not read the 24 pager so I could do it with you guys.
Good.
So that
The exhibits.
I have to read because of that. But like this kind of stuff, like I just wanted to show you like the reason that they do this, because a lot of people don't really understand why they're putting their appearance back in. So I was just going to kind of talk about that real quick and just kind of go through everything that we see today. Does that make sense? Like, I'm not going to read you all this. It's not necessary. But they had to put their appearance back in because they've actually been removed as the counsel of record. So for them to be able to file anything in the case of Richard Allen, they have to file a limited appearance to just say, hey, we're here for this purpose and this is what we're going to do. And then they do it, and then they can be removed again when that's done, when that's all taken care of. So that's just a simple, easy peasy. And then I figured the first thing, because it's kind of an individual on its own, is the motion to preserve specific evidence, which we've talked about this before, because they had filed it and she said that it was essentially too vague, which is like her favorite thing to say. And then, so now they have filed this one. So I figure we'll go through this, and then we're gonna hit the main points on the rest. And let you have anything you want to say before we get rolling.
Nope.
Yes, it's a good reminder. Anybody who's in top chat, make sure that you're in live chat if you want to see all the comments. Okay, so this is kind of a separate. That motion has problems. Oh,
They're gonna say she's gonna say this one's too vague too.
Yeah. Yeah. So this is.
It's like she wants them to like list one by one each specific thing that they want. Like DNA swab from Teresa. DNA swab from Ron Logan.
Oh yeah, she wants them to. She wants to waste their time. Reminds me of some other people we know. So this is their second motion coming in to preserve specific evidence. Comes down. If you want, you can send Michael the link if he's not busy and he wants to come up and go through the other motion with us, so he can hit on the highlights. Because you can grab the link, right? Yeah, right. Yeah, I think so. So it comes down Richard Allen by and through his counsel and moves this court order the state of Indiana, including the prosecutor's office and all of the enforcement agencies, labs, or state, federal, and local bureaucracies that possess any of the following evidence to preserve said evidence and not destroy or lose said evidence. Said request is made for the reason that said evidence may be used at any future trials should this case be retried or may be used by future post-conviction lawyers in the event, typo, that the matter is not overturned by appeal. So this is, I found this part just kind of interesting because of the fact that if you guys recall and you guys were watching the live, she's sending out emails to people saying that we can't FOIA request anything or we can't have the exhibits from Jody because she needs to retain everything and keep it in order for future appeals or retrials or anything like that. Mr. Osbrook, hello.
Evening.
Hi.
Hello, Michael.
Hi there.
They do need a
So,
motion writer, but not you. No
so
more.
Why
right now,
Steve.
not?
right
Why
now we're
not
in the
me?
motion to preserve evidence.
Unless they're going to leave it be.
I don't know. I have to look at the details. I've heard it read a couple times, and there's some things that kind of need to be cleaned up.
Mm-hmm. Also, I have to say, in the 24-page motion, for the actual motion, the one to correct error, you couldn't have denied having a hand in it, in my opinion, because there were some things that just screamed your name. Not just the footnote either. The minute I saw
Well, here's the
skullduggery, I thought,
thing: is
if he's trying
we've
to
read
hide.
so many of these motions, Sleuthy, like you could almost start to tell. Like I don't even have to
Yep.
look at the bottom, and I could be like, okay, this is definitely a Baldwin. This is definitely an Auger. This is and then Osbrook. I don't know if you were even on social media at the time when you filed. Oh my gosh. I had to make like a whole
The
graphic and everything
contempt
about
thing, I think.
it. But I made a
It was
whole
the contempt.
graphic to try to understand the filing because it was like the way that it was written. I was like, okay, now this is definitely a different attorney that we're not used to because I've got to like try to break this shit down.
He has a
I
way
didn't
of
design
writing.
the whole thing.
He's very, he's more descriptive,
Oh,
I think.
way more detailed.
Yeah.
And the legalese is definitely more in there. Hold on, let me see if I have that handy.
No. The legalese is no. That's what other lawyers do. I do not do the legalese.
Well, maybe that's what I'm used to reading then. But I'm telling you, like that one that you did, was it on contempt? It wasn't. It was on her.
Yeah.
Whether like they were going to go back and that you'd have to go back to the Supreme Court if she didn't pay
Yeah,
attention to what
and there
she
were a lot
did.
of citations in there for sure. But the English wasn't legalese.
He throws a lot of shade very professionally.
Maybe that's
They're
it.
like the most respectful. I don't even know the word. Like respectful draggings that I've ever seen.
I wonder if I have that still.
Well, I mean, when you get to look, legal skullduggery, I mean, you look at what happened at that safekeeping hearing, and nothing was done right. Nothing. I mean, I think somebody mentioned today on some live, if it had just been one, it might have been Michelle after dark. It wasn't a live; it was a video. And she said, if it had been one thing or two things, they screwed up. But I mean, there was literally nothing done right with that.
It was like 6. It was broken down into like 6 sections. It was by far, and maybe it's not actually, but it very much felt as though it was a large portion of this motion because so much of it was wrong.
Okay, well, so we're hopping ahead because that's not the motion we're talking about. So I don't want to confuse everybody because right now we're still in the motion to preserve evidence.
Oh yeah, sorry.
Yeah, well, I just don't want them to think we're talking about this one because we're talking about two different ones. So let's go through this one really quick, and then, like I said, this is kind of just a little like we're taking a little side street to where we're going to end up. So this is not connected to everything else. So that Richard Allen's attorneys request the following specific evidence to be preserved: all the physical evidence taken from the crime scene or near the crime scene, including any belts, cigarette butts, or any electronic items, whether or not they were working. All DNA swabs taken during the investigation or even during trial or afterwards. I thought that was interesting. All forensic evidence obtained during the investigation or even during trial or afterwards. Any and all reports or lists that identify anyone whose interviews were erased while in possession of law enforcement or the state of Indiana. All evidence identified on the state of Indiana's exhibit list or that may be exculpatory in nature. The items identified in 1 through 5 are not intended as an exhaustive list of items that the defense is requesting this court to order preserved, but rather are a few of the specific items that the defense is requesting following this court's previous denial of the defense's request to preserve evidence for lacking specificity. The state of Indiana has a continuing obligation to preserve any evidence that may be exculpatory in nature. So I agree with you, Sleepy. I think this is going to end up turned back. I think it's going to be too vague.
Hey,
Yeah.
so my problem with it is talking about stuff as evidence. I mean, they need to name the stuff. I mean, what do you mean by evidence? I mean, all forensic evidence. What does that mean? No, you want everything collected from the crime scene. You want. I mean, they mention a number of specific things. They don't mention, everything collected at the crime scene. There's some report that we have reason to believe that shell casings were collected. And I think there was almost certainly stuff that was collected and not put on any evidence list. And the idea that they, preserve exculpatory evidence, that
Seems subjective, and Nick doesn't have the best track record of turning over or keeping exculpatory stuff.
Well, he doesn't consider it exculpatory, so that's kind
Right.
of.
well, they have continuing Brady obligations at even post conviction, and that's kind of understood. I mean, something maybe should be said in there. Talking about bureaucracies, and I think you just got to name the agencies you're talking about. And one thing that's not in there is all tips past, present, and future.
Yes, you need those filing cabinets. That's what I would say. Every single one of the filing cabinets.
Absolutely. Absolutely.
Well, so
Because
this
as
is
of
most likely
trial,
going to get bounced back anyway. So hopefully they do add that to it. Yeah, they didn't ask to preserve the tips, and I think in the first one they actually did mention the tips.Id they not?
I don't know. I've lost track.
Yeah, me too.
as of trial, she still was in possession of all five or more filing cabinets. So that's definitely what I had to put in there, along with the Orion stuff. But it would be worth it to me to compare what she has in those filing cabinets to what's in Orion.
Look, we know the Orion thing is not complete. The Orion thing, my understanding is that that the Orion database is limited to 10,000 tips. We know from, I think it's Holman that, was it Holman who said there were 14,000? I'm not sure. Somebody said there were 14,000.
The 14,000, she testified that when she went back through Orion, you could type in a name or whatever, and it would bring up everything. If I typed in knife, it would pull up everything that said knife in it. If you type in a person's name, it pulls up every tip that they've touched. Kathy was saying that about herself, that when she typed in her name into Orion, it popped up 14,000 some odd entries that was attached to her name. But Holman did say that after like a certain point, they were realizing that, well, this is his claim anyway, that Orion wasn't combining things. So if it was a tip about Michael Andrew Osmond, then somebody called in a tip for Michael Osmond, it wouldn't show up as the same. And so they didn't know what all were connected to one individual. So she started doing the files, like they were doing filing. It sounded very much like he was saying that they dropped Orion and had her do filings.
Well, and so, Susan Hendricks, Kara told me, and her book says there were 77,000 tips, and that was some time ago. I don't know what the number is, but my point is they got to be saved.
Where'd you get that, Teresa?
I've had that.
That's the belt?
That's the supposed belt. Yeah.
Why do you say supposed?
Well, because it's I mean it's from social media, so I have no way to validate that this is the belt that the defense is actually talking about in their filing. So the alleged belt.
Do you know
There-
its
there-
location?
Location of this was supposedly closer to under the bridge. Once again, I don't know.
With
I
a,
have
bro-
Susan
with, a,
Hendricks'
with,
book.
with a broken buckle and a very
Mhm.
experienced IMPD detective. I'm not sure exactly how the story went, but he and in what context he said this and how people know about it. But he said something about the belt and the broken buckle, because he said it is very common in kidnapping situations for people to be grabbed by the belt and for the buckle to break.
Well, that's interesting. And then plus you have this weird line on Abby that nobody seems to know or care where it came from.
Well, and this is all going to be for the post-conviction investigation. So, it's not for the appeal. The appeal's based on the record. Yeah, so, maybe we'll get an amended motion to preserve evidence in.
I hope so. I'm looking. I have Susan Hendricks' book, so I was going to look and see how many tips she says in here, if I could find it.
I mean, to give you an idea of how important this stuff is, I know I've said this elsewhere. I mean, I had a case where it was a former death penalty case, and there was literally a court order to preserve all the biological evidence. And the Indianapolis Police Department, over a court order to preserve it, destroyed it.
Jesus.
And isn't that usually how like wrongful convictions get overturned? It's by stuff like that.
Not in this case, because they just came in and said, we had our schedule for destroying stuff. We didn't know anything about that order. That's why it's so important for in the preserve evidence thing. It's important for whatever the order to preserve says, that it has to instruct McClelland to notify Sheriff, Carroll County, Delphi PD, FBI, state police, to actually, notify them to preserve this stuff. And that way, if it gets destroyed, then you've got a bad faith claim.
I think she's still looking for the tip number.
I was, but I put it down now. I'll put it down. I'll look for it later for you, just so I can. I'll take a picture of the page for you. I found it funny though, because I didn't actually notice when I read the book that there's the picture of one of the pictures she has in there of Libby is Libby with the Delphi swimming sweatshirt on.
Thought it was brand new.
So I just thought I was like, oh wait a minute, she actually has this in here. No, so if you guys, the belt is this black strip right here. So just in case anybody's wondering what it is the baiting him? Oh Jesus. Okay.
And it's
Oh my god.
it's apparently been identified as maybe Abby.
Potentially, yeah. That's what the thought was, that it was possibly Abby's. Okay. So any other comments or thoughts that you guys want to share about the motion to preserve evidence?
No, the idea of doing it's great. I think maybe an amended version, and maybe I'll take it and propose to them an amended version. And I'm not saying I've got the list entirely right. And you put people together and work in a group, and You know, you
Right.
come out with a better product.
So I do think that she's going to knock it back, saying that it's not specific enough. It's too vague, and they're just not. That's just saying that they're not going to keep everything. So tell her what you want kept. But okay, so the big one for today and all of the exhibits that go along with it is the defendant's motion for, well, they have the motion to correct error and then the request for a hearing on the motion to correct error. So this is the defendant's motion for hearing on the motion to correct error. So I'm going to just go through this because it's shorter, and it's essentially just them asking for a hearing based upon what we're going to read on the next 24 pages.
You really don't need to go through that. There's just a requirement in the rules that if you want a hearing, you have to file a request for the hearing by separate motion.
Okay.
It's stupid, but you do. So that's why that was filed, and that's all it is. It's a request for a hearing on the motion to correct error.
No real details.
Yeah, I'm just like I said. I just wanted to tell them everything that was filed, so if they go back to look through it, they know what they're looking at. So that's perfect, Michael. So the next one is the motion to correct the abstract of judgment. Why is that filed?
That's being filed because there's a box on these so the abstract of judgment is a form that actually by which the judge actually authorizes the custody of somebody by the Indiana Department of Correction. In other words, so it's not the sentencing order. The sentencing order creates the sentence. The abstract of judgment is what gives the Department of Correction the authority to hold somebody.
I think we have this.
And the reason, so she did not sign, there's a box on it about whether the person who's been convicted and sentenced has mental health issues. And that box was not checked originally. And I think so they filed this to get that fixed. And what effect in the DOC that in the Indiana Department of Correction that has, I can't tell you. It may change, some sort of classification. I don't think that box being checked makes a difference about whether Rick gets sent to Newcastle or not, where they have the psych facilities.
What are you saying you have, Sleuthy?
The form that he's talking about, the form that it's asking them to correct.
That she doesn't actually mark where there's mental health issues. So so they're just saying correct that. Okay, so let's go to the next one. Here's your big one. Let me blow it up. So as we go through this, we'll touch on what basically is over here. Okay, so we'll take this a section at a time so we can break it down, especially now that we have Michael on here who can break it down much easier. Okay, so this is the motion to correct error. In violation of the 6th and the 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding, quote unquote, of November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel. And under United States v. Chronic 466, I'm not going to read all that, and the court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. The Indiana Code governs safekeeping proceedings for pretrial detainees and provides in full. So this is the statute here. Hold on, let me see what you just sent. I can show that, right?
It just lists the people who can file for a safekeeping hearing and the things that have to be found that justify a safekeeping order.
None of those things were done. We actually talked about this, remember? I think it was here where we were talking about how Michael was explaining to us about, like, once Lesenby moved him to White County, that at that point it became the White County Sheriff's, I guess, responsibility to request a safekeeping order because he was no longer in the custody of Carroll County or Lesenby.
Well, and if you look at the statute, the people that it lists who can file one of these motions for a safekeeping order says the sheriff, right? And so it has to be the sheriff where somebody's being kept, because otherwise
Not
what?
not
Uh,
a sheriff.
yeah.
Am I allowed to show that, Sleuthy, or no?
Yeah.
Okay, I thought
Yeah.
so, but I just wanted to make sure before. No, the form, so that people could see the form. Sleuthy just sent it to me. Sorry. So mental health concern down here, no. So if anybody wanted to see that, where it was marked no instead of
Which is
yes.
kind of like absurd after everything that she saw for her to. I mean, I think it's clear there's even if the craziness with the confessions hadn't happened, I mean, he has a documented history of mental health issues.
Who actually fills this out?
Well, that's a good question. Yeah, judge signs it, so my attitude about this stuff is, look, every pleading that I sign is me. I mean, I'm responsible for it. So if she signed it, she's responsible for it. I don't really care who filled it out.
Yep. I agree with that.
I agree with that too. Okay, so we'll move on to Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27, 2022, Kathy Allen, Mr. Allen's wife, hired attorney Brett Gibson to represent Mr. Allen. So we'll go to.
Going all the information that's in the exhibits. I mean, I'm not saying people shouldn't look at the exhibits. I think they're all available on Delphi Docs, but all the information in the exhibits is really in the motion, so you don't really need to go flipping between them.
Yeah.
Okay.
The only thing I would say is if you
Like I
want
said,
to
I haven't read this 24 pages, so I've only looked at the exhibits. So if you feel that way, I won't flip back and forth.
Look, it's it's your channel, T. You can do whatever you want. My suggestion is that the motion is interesting, the exhibits are less interesting, at least on their own. It's how they're used that matters, and all the information in the exhibits is actually, except maybe for Eldridge's at the end, all the information in the exhibits is in the motion.
Okay, gotcha. All right, we'll go that way. I'm good with that. I'm good with time saving. It's already 7:00. I'm not looking to stay here all night, even though I
and
know some people in chat are like, let's do it.
if you are going to look at like the footage ones, I would suggest the one it's like 1 minute long, and it's the far away view, and then it zooms in and it gives you that view, and then it zooms in again and gives you that view.
And I might. I mean, what happened at the safekeeping hearing is terrible. It'll be fun to read through that, but your audience might actually find the van section a lot more fun and interesting.
I think they're definitely going to find the van section very interesting.
They want to know it all, Michael.
That was a big thing for me, but they like to know it all. They like to know everything, which is, I mean, I can't fault them. That's exactly how I am. So, but Chelsea hasn't heard the motion yet, so we'll go that route. If we do see something that we think that we need to pop over, I looked at the exhibit, so I do know what there is in those, so we can just pop over if we need to. So the affidavit of Kathy Allen and Sleuthy, would you drop your? Is it okay to put your Google?
I can, but I don't think that it. Oh, actually, let me get on my pad. I'll do that from my pad. But it won't let me put the whole folder. I have to do like individual links, which is fine.
What?
Yes. CH told me that earlier because I forget where we were that I was trying to put the actual folder in. It wouldn't let me do it. So, but then I
Try
could
it.
do
See what
individual.
happens.
Let me try.
Okay, so in the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to the prosecutor, Nicholas McClelland, which is Exhibit 1B. So what emerges from the defendant's Exhibit 1C and 1D is the following. Sheriff Lesenby confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27th. Also on October 27th, so anybody who is missing out on the timeline here, remember October 26, 2022 is when Holman tells them they can come and pick up the car They go into the station. He does the accidental interrogation of Richard Allen, which ends up in his arrest, but they don't actually charge him with the 2 felony counts of murder until October 28th. So just a little bit of a timeline. So we're talking about right here in the middle of this. As soon as Kathy leaves, she's contacting an attorney and saying, hey, we need some help, pays him some money, and says, my husband has been arrested. So just timeline-wise, we're on October 27th, right in the middle of all of this. So also on October 27th, however, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McClellan by email, after which Mr. McClellan called Mr. Gibson on his cell phone. Mr. McClellan told Mr. Gibson that Mr. Allen was listed at the jail under a different name/alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson, the regular jail staff did not know Mr. Allen was there. Still, on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. At about 10 p.m. on October 27th, Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. So on October 28th, without Mr. Gibson present, even though Mr. McClellan and Sheriff Lesenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there, and it is shown filed in this court on November 9th of 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. That's interesting. I did not know that.
Well, now I see why they didn't file. Now I see why they marked it as filed on November 9th or whatever, 7th or 9th, whatever you just said. Because if they had put it in as filed November the 1st, then what effect would that have on the fact that they did this whole safekeeping thing without him being there and having an attorney? You know what I mean? Then it'd be in the record that he asked for an attorney before that motion was filed, which would mean that they needed to be served and whatnot, or informed in some way. You know what I mean?
Correct. So he's on the 28th, after his initial hearing, he's taken to the White County Jail. The White County Jail, he's booked in as his actual name because now they've actually filed charges on him. So, okay, I don't know if you guys even can answer this. Why and how would it be legal to not technically have charged him with anything, even though I know that you can detain him for 48 hours before charging him, but actually book him under a pseudonym?
I've never heard of that, but I've said let's give these folks the benefit of the doubt. They were worried about his safety, and they didn't want people to know he was there. I mean, this was a big deal in Carroll County.
But how unsafe was he? Even the staff didn't know he was there.
But how unsafe is he if they haven't charged him with anything yet? He doesn't
Well,
have any
I mean,
charges, so there's no reason for him to not
well,
be.
well, they haven't charged him, but word gets around a small town in a hurry. Who knows? I mean, it gets out that Rick Allen's been arrested, and then people start looking to see if he's at the Carroll County Jail. I look, I don't know. I've never seen it happen in another case. I don't know that it doesn't happen elsewhere. It seems very odd, but I think maybe they were trying to protect him. And I think Lesenby's safekeeping order, let's give him the benefit of that on that. He was worried about being able to keep Rick safe there, but they just didn't do. I mean, when you get to the list of things, I mean, nothing was done right in that safekeeping hearing. I think maybe we should just move on and you'll see.
Okay.
It was a total bollocks. And I started saying earlier in Bob's life, one of the things that worries me about this is, there are a lot of small counties around Indiana. There are a lot of small counties around the state. I'm worried that this kind of thing goes on all the time.
And if you give him a pseudonym, would you give him a pseudonym to people of a person who you've actually booked into your jail before?
Yeah, that part of it is so weird.
Yep.
The whole thing is weird. I'm not saying it's not weird. I'm just trying to say I don't know that there was any evil intent here. And by the way, when Brett Gibson called the jail, they didn't have him there. Gibson got in touch with McClellan. McClellan got back to him and arranged the meeting. So they really weren't. I mean, this was not trying to hide Rick from his
But
lawyer or family.
but at the same time, then they made that name available to the media. And also, I guess it was the 28th. I'll have to go back. I keep referring you back to my short, that one short that I did of the news clip people, and it was like October. It was either October 28th or October 26th, or maybe October 27th. One of those 3 days. And she knew who was arrested, his name, and the fact that he immediately was sent to the Indiana Department of Corrections when he was supposedly at that point still at White County. So how did she know
Oh,
that? She said law enforcement told her.
so I think I know at least I think I know the report you're talking about. I know of a report. Maybe we're talking about the same one. And it was the 28th, but it was after the initial hearing. So after the initial hearing, it was his name. It wasn't the alias. And it is very peculiar because the report is sources, I think it is sources tell us or tell the news station that Mr. Allen has been transferred to a state facility. Now, the reporter could have gotten it wrong, and that is that what he was really transported to White County, not to the DOC. It could be that
Teresa, pull up my
somebody.
short.
Okay.
It could be that somebody didn't misreport it, but that somebody with law enforcement, the sources mentioned in the thing, let the cat out of the bag that the fix was already in to get Rick to the DOC, and so it was.
Right.
But then they got it wrong that he'd already been there. So it's very hard to figure out what exactly happened here. So
This one, right? I'm assuming.
Yes.
You're not going to strike me, are you?
Maybe. Depends if you play the whole thing.
suspect. The case against Richard Allen, who was arrested in connection to the Delphi murders, is sealed. No information about whether he has been charged or if an initial hearing has been set has been released. Multiple sources tell us after he was booked into the Carroll County Jail, he was immediately taken to a state correctional facility for safety reasons. Now, Indiana State Police have scheduled a 10 a.m. briefing on Monday, expected to update the media and the public with more information related to this arrest. It is important to note that that will be 72 hours after this arrest, which is the limit on how long the state of Indiana can hold the defendant before releasing more information on their whereabouts and any potential charges. And one more thing we do want to know is that while he has been arrested in connection to the Delphi murders, we have not been told by law enforcement what his alleged role was in all of it.
Yet to be.
What was the date on that video of them?
October 28th, 2022.
Okay, because
Right
she
here.
said that they didn't even know about that, like that an initial hearing didn't even happen yet.
Yeah, no, that's true. And so is there, it would be good to go back if that's still on. Which channel is that?
That's mine.
No, the TV station.
Oh, I'll have to look. Probably.
I don't know. I can't tell. Fox News.
Fox 59.
Fox 59.
So
Fox
it I think those things only have the dates on them, but it would be interesting to know. So the initial hearing was in the morning. This news report, it could have been just before the initial hearing, so they didn't know that he was being charged. But somebody even before he was charged and his name was out, leaked it to the press.
It should say in the corner there, Teresa, at Fox 59, like above where the degrees is, it should say the time.
But the whole thing is that this is October 28th, and they're saying that he was transferred to the state penitentiary.
Yeah, right. And so what I'm saying is that, either they got it wrong. I mean, it's very, what's really strange about that was he wasn't transferred until some hours after the initial hearing. So if this is before the initial hearing, I have no idea what they're reporting, what their sources are telling them. And by the way, their sources could be clueless.
It says 6:30.
Yeah, is that 6:30 p.m. or a.m.?
But he wasn't transferred to the penitentiary yet. He was transferred to White County. So how did they know he was going to go to how did they know he was going to prison?
Michael, did anybody see him at White County? Like, is it possible that he was at White County for just like a day or a couple hours and then got moved to IDOC?
I think he was moved. No, he wasn't moved. He wasn't moved to the Department of Correction. He wasn't moved to Westville until the 3rd.
Right. So how on the 28th are they saying he got moved to the prison? How would they even know that?
I'm thinking they knew that was the plan. I think someone told them that was the plan.
I'm thinking that someone knew that was the plan, but mistakenly told them it was already had already happened or was already, just about to happen. So you might as well say it had happened. I don't know. I have no idea.
Interesting.
I mean, what happens is I don't think I've ever seen, like, on a single motion. I don't think I've seen, like, everything done wrong that could have been done wrong. Everything.
I think this was probably 6:30 a.m. because they said that he hadn't even had his initial hearing yet, but that it was scheduled.
Yeah, I think it has to be.
So
Very weird. I'm only trying to, y'all know me. I'm trying not to say that people are evil till I've actually got the goods. And when I got the goods, I'm happy to point out evil people.
yeah.
I'm with you.
Sorry for busting in on your. We're getting you sidetracked, Teresa.
Somebody had sent me this in my email, and I haven't responded yet about it. So I'm glad that you actually brought this up because It's important. Just don't go copyright me. Okay, so, but this whole thing about the mail, I think that's very interesting. I didn't know that the mail was considered filed as of the date that it was sent. So that was something I just learned. So the safekeeping proceeding was.
Well, let me interrupt you just a second. I mean, the logic of it is, I mean, it actually makes a lot of sense because you can't, prisoners can't control when their mail goes out.
Right.
And so, you know, I actually think Rick wrote this on the 31st, and if he had evidence of that, he'd actually get a filing date of the 31st. But, you know, in a world where pro se people going pro se have to file their own notices of appeal and things that have deadlines, it really would be very unfair to stick them with the deadline when they can't control the mail.
As long as they meet the deadline by giving the prison mail person, whoever that is, their mail by that date of the deadline, then it's right. Because one could give the people that take the mail it on a Monday, and whatever happened, that individual not actually send it out until Friday, and then the court not actually get it till the following Wednesday. How would that be the inmate's fault when they gave it to them by the deadline? You know, and they can't e-file, and you can't say, well, you should finish it in enough time to where you can get it to the jail staff quick enough so that they can, if there is a delay, it's still, you know, filed on time, because that just seems a little bit ridiculous. And also, it would cut down the amount of time that you have compared to the state, who can literally e-file like at 11:59 on the deadline.
And by the way, it's set up in the Fed courts now, so
I think that's reasonable.
it's set up in the Fed courts. It's not set up this way in the state court yet. They should do it, but for even state prisoners, if they're doing federal habeas cases, they can, on their own, they can file electronically.
Really? I mean, they
Yeah,
should be able to. They got tablets and shit too.
well, they give it. There's a guy at the prison who will file the stuff in Fed court, so it goes through them.
What?
But
Okay.
hey, there are things about the system that, you know, work well.
Well, then there's things like this that just don't. As the filing says, the safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make the safekeeping request on November 3rd, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under the Indiana Code. Because Sheriff Lesenby had no standing to make the safekeeping request, Judge Diener had no jurisdiction to consider it. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. A judgment is void if it grants rights or relief to a party that does not have standing to pursue the action. Okay, so are they not? They have to have a safekeeping order to transfer them to one jail to the other. They can't just be held there, but still under the.
Look, if you scroll up to the statute, if you scroll up to the first part of the statute talks about a safekeeping order for transfer to a county jail or the Department of Correction.
Well, he was transferring him under, I guess, the guise of safekeeping. So regardless, it's not like we're talking about, hey, can you keep him here for a little while? I'm trying to make a room ready for him or whatever. We're talking, I need to send him to you for safekeeping.
No, I don't, because of this statute, if you look at it, the transfer from one jail to another, just like a transfer from a jail to the Department of Correction, requires a safekeeping order. I don't think the sheriff gets to just say, "Hey, White County, would you take this guy for a while for me?"
Yeah. I mean, I don't think they should just be able to move you around like that all willy-nilly anyway. They should have to, especially when you're talking about moving you very far away from your lawyers and your family.
Okay, so second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft his safekeeping request in violation of Rule 310 of the Code of Judicial Conduct. This rule prohibits judges from drafting or reviewing documents except for family members.
I really wonder how much of this Diener knew was absolutely wrong and what part it played in his recusing himself very abruptly right after signing
I don't know,
this.
because there's always been the speculation and the I'll say rumor, if you will, that there was the two probable cause affidavits, and the reason there was because Diener told them to go back and fix whatever.
Mm-hmm. So it would be better.
Right. I don't know.
And perhaps
That's
why things got
total rumor. So take that for what you want.
Sorry, I'll shut up.
Okay. Let me see where I was. Judge Diener also violated Rule 2.9 of the code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. Having violated both Rules 310 and 2.9, Judge Diener was obligated under Rule 211 of the code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd. Yeah, he signs it and he's like, okay, I'm going to bounce now. Have fun, guys.
Mm-hmm.
So a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Okay, so I think that one's all pretty self-explanatory. I think everybody gets that one. So third, Sheriff Lesenby's November 3rd, 2022 request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached.
Can I just want to interrupt here. The editors went to work here. The whole name, it was just safekeeping request. And some lawyer editor, who shall remain nameless, stuck in this whole useless name of the filing. Everybody knows what it's about. This is what kind of ruins the sentence. Pardon me, my interruption.
Oh, no, it's welcome. Thank you.
Oh, I agree, Michael. I agree. I actually was doing what I told you I was going to do, like in comparing stuff. And I also noticed that the entire long ass name of that filing was there. It seemed unnecessary because he only filed one motion.
Yeah, I know.
Okay.
Also, please don't be an asshole in the chat.
Yeah, I hope nobody's being an asshole. I wasn't even looking. Sorry.
Go ahead. You can keep going.
Okay. Where was I? I was not served on any. There is no certificate of service attached. Indiana code requires a safekeeping request to be made by a motion. Indiana trial rules require that Sheriff Lesenby's motion for a safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was required to then serve Mr. Allen personally. about the hearing, like beforehand, but there is no hearing. They don't even have a hearing. He just signs off on it, right? I mean, it's kind of like we don't even know where
The
this actually
motion,
transpired.
the motion that was filled out would have needed to be served to Gibson or Rick. The motion that
Okay.
Lesenby filed. You have to serve. He had to serve one of them.
And he served nobody to let them know
Nobody.
that he was even doing the safekeeping request.
Correct.
Okay, so fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana code that would authorize a safekeeping order. Because there's no hearings. This is all like back office kind of shit going down.
That, and even in the motion itself, Lesenby didn't put anything in there like evidence wise or nothing to back up what he was saying.
Right.
No, he didn't sign it under penalty for perjury. So if you sign something that's verified, it's kind of like you're testifying. But he didn't sign it under penalty for perjury. So it's just, it's just a motion.
I've noticed other filings without that little piece in it also.
Nick McClellan files all kinds of stuff and claiming stuff, and he's literally testifying, and he doesn't verify things, and most of the stuff he says just isn't true, by the way.
Yeah, but he's not signing it under penalty of perjury, so.
Okay, so sixth, and perhaps most importantly, Mr. Allen had an absolute.
I'm going to interrupt something.
Good.
One thing he did sign under penalty of perjury was the first time he heard about the leak was on October 4th. And I'm not saying it isn't, but there is certainly some evidence out there that he heard about it at least 4 days earlier.
Yeah. Okay. And
oopsie.
So Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. We've read that one quite a few times because it never made any sense that they don't bother to pay attention to that part of the Indiana code. And then they changed it to that it was for their own safety later. And then it was for the fact that they were doing the construction in Carroll County, and it was all these different things. But his motion, it says, for his personal safety. They couldn't keep him safe. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is for quite a simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility, and Cass County Jail for 23 months pending trial, because Mr. Allen had no notice of what was afoot. Neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer.
Fuckery. That's what was afoot.
Yeah, the skullduggery.
That's my
I think it'd say fuckery if it wasn't a legal motion.
That would be my motion.
There's all kinds of fuckery going on.
There's clear fuckery afoot. But Richard Allen didn't know.
Okay, hold on. Let me see what's going on here. I agree. What's wrong with Thomas? I don't want Thomas going. No, no, Thomas, don't leave. Please don't leave. Okay, I can't read chat and this though, so I don't know what's happening. But please don't go anywhere. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards as trained lawyers. One consequence of this should be that the Sixth Amendment and Article 1 of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. So the safekeeping, quote-unquote, proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above. Critical stage is essentially significant consequences for the accused. Yeah, I think there was significant consequences for him there. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping, quote-unquote, proceeding, the court must presume Mr. Allen was prejudiced by that deprivation of counsel.
I mean, there's a reason they didn't let there's a reason they did not tell the lawyer that that's what they were doing. I mean, let's be so for real. Because he could stop it.
And so what, they just figured that no attorney was ever going to care, or they just weren't going to ever be able to get him out, so it didn't really matter?
Yeah, I mean, good luck reversing something like that after it's already been done. They tried for a year.
But how would they know that going in is my question. Unless they've done this multiple times, which I don't think they have. Otherwise, we would hear a ton about all these
not with pre-trial folks.
Pre-trial detainee. That's what I'm saying. So it's like, how would they know that that would work out in their favor by excluding him and doing it this way?
Because I think they would just say what was needed to keep him in safekeeping. And then he started going crazy. Then it was, we think that he's safer. We don't have the mental, clearly now he needs mental, he's got mental problems when it's convenient for them. And then other times he doesn't have any at all when it's not convenient. So if he needs to be moved, he can't be moved because they don't have the mental facilities. They can't have a doctor see him all the time. If he's psychotic and doesn't know what he's saying, Nick's saying he's perfectly fine. He's actually back to baseline and doesn't even require any medications involuntarily. It's very much when they went to go move him again, in that June hearing, a lot of it was that he needs the mental health. He needs more mental health treatment than what we can give him at the jail, at any of the jails. And it was kind of undeniable at that point because he was actually crazy. So
he needs more mental health treatment than we can provide at the jails because the Department of Corrections has driven him nuts,
right.
and only that institution, which has driven him nuts, has the facilities to treat him.
Yeah. Well, if you're Dr. Walla, then you believe that the best thing that ever happened to Rick in his depression and anxiety was going to prison. It cured him of his depression and anxiety.
Look, I didn't know anything about this case back in the. I was focused on the contempt stuff, and I really didn't know about the solitary confinement part of it. I don't know that I could have gotten him out of the DOC, but I could have gotten him out of solitary pretty quick. It is just unconstitutional to keep people in those pretrial detainees in that condition. Get the footnote 1, you'll see.
I just simply don't. I just in all the things that I've put together and all the stuff that I've read and timelines and information that I've put in a way where I can see what other things are happening at the same time other things are happening. I just don't understand how anyone could look at this and not consider it we put him in this situation. We know at this point that, how much he needs to be able to speak with his wife and see his wife. So we're going to put him in solitary. We're going to deprive him of sunlight and human interaction. We're going to, he has this broken tablet. We're not going to replace it. We're not going to allow him in-person visits. They didn't even let him speak. They did not even let him see his wife until after he'd made these confessions. And he very much, history would support the idea that he absolutely at some point would say whatever to be able to see his wife. Like the worst thing they could have done was kept her from him. And I just think that it's very clearly, in my opinion, this, yeah, conditions that were meant to make him insane as a pretrial detainee to confess, to say things that they could use to incriminate him, since they didn't get any from his interrogations because Holman sucks.
Well, I agree with you. I think this was all set in motion. I obviously have no proof of any of that. This is my theory. I think it was all set in motion when Holman was like, let me take a crack at him. We'll get him in here and I'll get him to confess. And then he doesn't get him to confess. So he books him anyway. And then they're like, well, we've got to get a confession because what we have now isn't enough to convict. So how are we going to do that?
And you know, the communications between the DFC and other people, between Walla and other people, will quite possibly come out in the discovery in a federal civil suit that I very much am hoping will be filed. And actually, if it isn't filed pretty soon, I may just have to file it myself.
I think you're right, Teresa. I think something else that would be important, perhaps to the civil suit, nothing else, maybe. I'm not entirely sure. My curiosity, a personal task that I would take on, would be seeing what kind of communications Holman had with people at IDOC. So, guards, Dr. Walla, anybody that was responsible for day-to-day interaction with Richard Allen. Because I think that he made it his personal, this is just my opinion based on everything that I've read and seen. It would be my opinion that his ultimate goal was to get a confession that he did not get. And I think when he didn't get it, when he did not get it on October 26th, I think no one else will admit it. But when he said in that interview that they did not plan to arrest Richard Allen, I think they did not plan to arrest him. But I think Holman planned to arrest him. I think Holman planned to get a confession and arrest him. And then when he didn't get it, he got angry. He'll sit here now and tell you that he only yelled and cussed for 20 seconds out of the whole hour something, when an entire courtroom of people, all of them said that is not true and absurd.
Well, not all of them, because the person interviewing him doesn't call him on the lie, but whatever.
Well, she didn't call him on it, but if you go back to her lunchtime live, she says it. So, like, you know, everyone reported consistently about the craziness of that interrogation. And I think that he got angry, and I think he arrested him. And at that point, it was a scramble for everyone, including Nick McClelland, to come up with probable cause. They did it without a warrant. It took them days to write a probable cause affidavit. I think that's also why changes were made to certain things in order to make them more compelling, as mentioned in the Franks memo. I mean, the whole thing is so clear to me, in a sense that I don't understand how it's still debatable. It just seems really simple and obvious. You know what I mean?
Debatable because the judge on the case doesn't agree.
So what you're saying, Sleuthie, is basically this all. So they didn't plan on it. It may be that Holman didn't even plan on arresting him without a confession, but that he got so pissed off at the interview and not getting a confession, he arrested him anyway.
Yep.
And that was the first domino, and it's been basically covering for Holman's action taken in anger ever since.
Yeah, and I think that other than the initial like probable cause, that like I think that McClelland, and I also think that's why McClelland was so offended about the Frank's memo, because I think that a lot of the statements that were attributed to like Liggett was actually Nick writing the probable cause affidavit. I don't think Liggett sat there and wrote the probable cause affidavit. And I know Bob would back me on this in terms of a prosecutor wanting to write the affidavit for a case this large to make sure that the person that they've arrested now for this will stay in prison, stay in jail.
Look, I wrote the look. Yeah. I mean, I don't think there's nothing wrong with
Right.
McClellan writing it together with
Yeah. Well, he knows the
Liggett.
law.
Well, and so, I mean, look, I wrote all the except for Brad's. Except for Brad, I wrote all the affidavits for the motion to correct error in conjunction with the witnesses.
Yeah. And then they just look at it, they read it over, and they say, yeah, I agree with all of these things, or yes, all these things are correct, and then you sign your name. But I think that
Yeah.
that's what happened, and I think Holman went through a lot of efforts to cover his butt and like keep this going. Like, for instance, he brought this up in an interview, and I'm sorry, Teresa, and then you can keep going, but he brought this up
No,
in an
you're
interview,
fine.
and it's still like stuck in my brain that he said it, because it was like a light switch went off to me when he was explaining how the deleted part of his interview with Richard Allen, when he says that whatever his excuse was, where he didn't read him his Miranda rights, right? So then he goes, I thought that they were going to give me a harder time. I can actually pull up the actual transcript, but he said that he thought they were going to give him a harder time, and that something that didn't make its way out in court that they did not mention was the fact that he went to interview like 3 inmates at Westville to discuss things that Richard Allen had said. And when he went in, he interviewed them. They didn't let him bring his, he says they didn't let him bring his recorder because they have their own. And he went in and he interviewed all 3 of these people. And then when they went to go like give him the thumb drive or send it an email, whichever it was, come to find out his interview with these 3 inmates was not recorded. So he got his recorder and went back in to re-interview these people. And I just immediately thought, so how is anyone to know that whatever you said to them prior to this second time, which happens to be recorded, that you didn't tell them exactly what you needed to hear? It's just weird shit like that. Like, all the weird shit just happens to happen to Jerry Holman. And it's things that propel the case forward. I don't know. It all just seems very clear to me. Call me a conspiracy theorist, but I mean, it's almost so obvious that it does sound absurd, because it just is, just to
Well,
me.
I'm at the point now. I've really just come down to listening to these interviews with people, the law enforcement, the investigators, the prosecutor. I'm almost at the point where I feel like their theory is the conspiracy theory. Like, I know that doesn't
Yeah.
really make sense, but it's like,
But that it's okay.
none of it adds up. It's like 1 + 1 does not equal 2, but we're going to say it does. And then you just have to trust us that it does. And we're just like, oh, okay, that makes sense. You know
Just
what I
like
mean?
now,
That's
just
where
like
I'm at with
now,
the whole
all
thing.
when we were talking the other day, just like now, all of a sudden, now Nick's coming at his face that his tip was never misfiled. They knew where it
Right.
was. They just didn't look into it because it said he was cleared. And
That's
it's
not
like,
what he
what? That's
testified
not what you
to.
just said.
But that's also not what Kathy Shank testified to.
Yeah, well.
But it's just like, it's okay. It's okay because we all think Richard Allen's guilty, so none of this other stuff ever matters, because it's just, we got what we wanted in the end. So who really gives a shit? Why is that even important?
Yeah. I don't know, man. I feel like I could, maybe not to Michael. I think Michael would be my biggest, like, pick, like, he would pick me apart. Like, where's your proof of this and that? But just in general, I mean, I could tell a pretty compelling story using things that have happened, things that were testified to, things that these people are saying in interviews, filings from the time that this all started to now. And it makes sense in my head. And do I think that all cops are bad, or that everybody's covering for whoever? Not necessarily, but I am firmly of the opinion that anytime there is some type of what one would call a quote cover up, it's never like to protect the real killer. It's like to protect your own ass. You know what I
Yep.
mean?
Well, that's what I've said from the start, is that it's the lies are to cover up the incompetency. So the corruption is to cover up incompetency. That's where I'm at with it.
Like, for
Yeah,
instance,
go ahead.
for instance, let's say that I'm working with you in small town West Virginia, and you're the sheriff, and I'm working with you to sell drugs, and I pay you a port. And if you think this doesn't happen, I don't know what more to tell you other than that I could probably get all 1,000 people in the town that I lived in before I lived here to tell you it does happen. And my ex-husband's grandpa was the sheriff. I'm not saying he did anything bad, but like, it almost seems like the people who are more willing to be honest about shit that bad cops do are like people that have family members that are good ones. And so I'm not oblivious to the fact that this happens, and especially in small towns. So let's say that I'm working with you, Teresa, you're the sheriff, and I give you money to pretend like I'm not selling drugs here. And you leave me alone, and I leave you alone.
That's right.
And then I kill somebody. Well, if you are paranoid that I'm going to put you on full blast and you're going to lose your job, and your family's going to be like excommunicated from the family, and you're going to be arrested for doing illegal shit, then you might be willing to kind of turn a blind eye.
Yeah, but you
Not
also
for them, but for you.
But you have Carter saying that people are going to be surprised that this person is a local and a prominent from a prominent family or a prominent figure in the community. I can't remember it verbatim, but
Prominent figure in the community that like nobody's going to believe it,
yeah,
or they're going to be shocked. Whatever he said.
hold on.
Matt Falk. I mean, it's extortion or blackmail.
I gotta check dates. Or I gotta check dates. I gotta check chat real quick. Hold on. Somebody said check chat. Okay, what is this? Okay, I'll have to look at that later because I don't know what that actually means. It's too colorful for me to look at right this second.
What were you going to say, Michael?
I think what you're saying is kind of, and maybe we could get Nick McClelland and voir dire or opening statement to explain what circumstantial evidence is with snow and stuff. I mean, I think what you're saying is there's a strong circumstantial case for collusion here, and I don't disagree. And but this kind of stuff for me, I mean, there are other explanations that also kind of fit the data. I'm with you. I mean, I'm highly suspicious. And I just like to see something more than a circumstantial case. If I'm the prosecutor here, I want some hard evidence. I don't want just a circumstantial case before I start saying people are doing the kind of thing that you're suggesting happened. And I'm not saying it didn't happen. I'm just saying, for me, before I start saying people are doing this stuff, I want more than a circumstantial case.
Right.
I mean, one could add what he did to Fortson. I mean, you don't just
see, and everybody I'm going to interrupt you here. Everybody puts it on Holman what he did to Fortson. It's not on Holman. It's on Dahl.
It's Dahl. I know, and I do agree with you. I agree with you. At the same time, I just think that tactic wise, I think Holman is comfortable with particular tactic. First of all, when you think about the things that he's done, that we like know he's done or whatever, and I guess what's appropriate is usually to chalk it up to competence before you say that it's corruption, right? But how do you keep getting promoted? And like, I just don't see someone who's incompetent continuing to go up in the ranks and then have a presser where the superintendent of the Indiana State Police says that he'd crawl across shards of hot glass for him. That doesn't sound like you're talking about someone that is incompetent. You know what I mean?
Yeah, I absolutely got. I don't think you've heard me say you're wrong.
No, you didn't. No, you did. That's got to be. Is that like a lawyer trait? Am I? Because I mean, I'll argue with a brick wall. I know you didn't say you disagree. It's just, I, there's just a lot of things. I mean, I could probably write you up something. It won't be as compelling as anything that you can write, but I bet you I could give you the bones to write something really compelling.
Yeah,
Like, I
If for
don't think you
nothing
heard
but
me.
shits and
I don't think
giggles.
you heard me say you're wrong. That's not what you heard me say. Okay, let's get back to this so we can keep going.
well,
Okay.
tell me something. I mean, this Frank Meister character doing more like complete non-facts. I mean, it says he's got something here. He was arrested the 26th. He was hired that day. Charges filed 2 days later. I mean, we've got the evidence. He was hired on the 27th. I mean, it's
Literal
like,
evidence
yeah. I mean,
available
just
to you and everyone else.
yeah. I mean, just stop it.
It seems like an insane thing to continue to, like, will we not believe it until Nick McClellan writes his reply and says, yes, I do know that he was hired on the 27th, before we'll actually, like, is the email not enough that he sent to Nick McClelland?
I mean, over on Reddit, the lynch mob is saying that Lesenby consulted the county attorney, and it's like, no, he said himself that he had in the 6/15/23 hearing that
Yes,
he had Diener do it, and and
100.
I, and I just don't know what these people by repeating over and over just things that are as fact that aren't fact, and if they think they repeat them enough, they become fact. It's
Yeah,
nonsense.
that's exactly what they do. That's exactly what some officials do. They approve.
And Gray Hughes keeps saying, you know, Rick Allen said he saw 3 girls, and there were 3 girls. No, Rick Allen said he saw 3 girls. There were 4 girls
Exactly.
later.
He also said that he saw one girl that was older, like she was babysitting the 2 other girls.
Yeah, yeah.
I'm even at the point where I've said for so long that we know there was a group of another 3 girls that were Libby and Abby's friends that were there. I'm like, okay, well, that's obviously not the same group that Richard Allen would have seen if he's saying he saw a group of girls and one was older babysitting the 2 others. Like, I'm at the point where, like, okay, so the 3 girls I always thought are not even the 3 girls, but they can't let that go. It has to be those 3 girls. And then they continue, and they've done this forever, to continue to say, well, one of the girls was really young, so they don't count her.
Yeah.
She
What?
still fucking counts. She still
Yeah.
counts
Look,
as a human being and a person that would have been there. And she wasn't like 2, she was like 10.
She might not be
look.
a witness, but she'd still be included in the group.
She could still be a witness. 10-year-olds testify all the freaking time.
After the conviction, the lynch mob, if you listen to them, spent a great deal of time talking about how, oh, eyewitnesses are so unreliable, because of course they don't fit. If you believe the eyewitnesses, then it's not Rick Allen, and it's just, Rayleigh Voorhees says the guy was taller than she, and she was 5'8" or 9. So the guy,
Oh, but they believe her, though. They believe her. They specifically believe that she saw Richard Allen and that she said so, and that Richard Allen saw her specifically and that he said so in his interview. It's so
yeah,
bizarre. I mean, I guess it's gaslighting, but you have to wonder if it's
Kinda
gaslighting or if they actually
gaslighting
believe the
tone
things
here.
they're saying.
I just, it's just exhausting for these people to,
Why
an
are they still talking about it?
honest examination of the evidence. Look, I have always taken these confessions seriously, and that they're a problem for the defense. And if you want to believe in the bullet evidence, well, if you believe in the bullet evidence, that's pretty bad for Rick Allen. I don't believe in the bullet evidence, but you can't have a discussion about something if people are going to just insist that
Right.
things are facts that are not facts.
Well, just like the confessions, well, Rick's in psychosis are, he said so, so we should believe him because he told us what he did. But then, like, today's filing comes out and they're like, oh, well, some of this stuff that Ron Logan said doesn't even match. And it's like, do you forget the part where, like, Rick Allen said that he shot the girls in the back? Or, like, that he killed family members that don't exist? So it's not like, I don't know. I don't know. I almost wished somebody would have said that Libby's wounds were vertical and Abby's one wound was horizontal, because that would really put all of this to bed for me. I'm still waiting for that detail from the killer that I'm certain only the killer would know. You know what, Michael? It's even interesting, like in terms of the confessions, and I don't remember, and maybe there was one or some that I just don't remember. Like, did Richard Allen even know that, like, one of the girls was naked and one was clothed in the other one's clothes? Even something simple as that?
Did who know?
Richard Allen. Like, was that in any of the confessions? I don't remember. I don't think
No,
so.
no, no, I don't think so.
So it just seems just strange. I don't know. I don't even think he knows where the crime scene is.
Well, it's yeah. I'm sorry. I'm just on a rant about, and it's too bad because I mean, some of these people, certainly on the other side, I mean, they're not stupid, they're intelligent, but and it would be nice to be able to have a discussion, but you just can't because it's a rant.
Yeah.
Okay, sorry, I had to step away. Are we ready to go?
Yeah, we're just here bitching and moaning.
Okay, so
Mainly me.
oh, you're good. Travis wants me to make sure that to ask Michael to discuss the importance of getting these issues in the motion to correct error that the COA has to consider and why it's important.
Well, I mean, we're dealing with the first issue here, and it's right to counsel safekeeping hearing. The point of the motion to correct error is that we now have evidence in the record that Rick was represented. We've got we've got the claim made that he was deprived of his right to counsel at a critical stage. So this is teed up for the appeal. The facts for it are in. Whether Mark Lehman and Stacey Uliana use it, it's going to be up to them. I would hope they would, because there's a standard. There's no harmless error standard. It's automatic. It's an automatic reversal if the Court of Appeals agrees that it was a critical stage. He was deprived of the right to counsel. Just an argument. I don't say it wins. I like it a lot, but that doesn't mean a court's going to agree with me, or it's going to win, or that even Stacey and Mark are going to use it. The other reason, if you go through the other issues in the motion to correct error, the white van, the court testimony about the box cutters, and the Logan confession, which wasn't in the record before. If there's no hearing, then the Court of Appeals in the appeal has to take at least the facts in those bits as true. And I was saying earlier on Bob's Live earlier this afternoon, if I were a pro prosecution judge, I might hold a hearing because that gives the state its opportunity to put on evidence to counter this stuff, and that's fine. I mean, that's what hearings are for.
Mm-hmm.
I know that one channel was saying, "Oh well, that those timestamps on the video are inaccurate, or how do they know they're accurate?" And I can tell you, we've got some ways to prove that they're pretty accurate, and I
But it's
think
People
up
are
to
saying
we're
that
working.
the timestamp on the Weber van video is inaccurate.
but it's up to the
How would they
prosecution.
know that?
The prosecution would have to, in a hearing, show that they were inaccurate. Otherwise, they're accurate.
Right. The Court of Appeals would have to. I mean, there would have to be a hearing, and frankly, I have my own suspicions about that video. I think it's actually, there's some reason to think it's a little bit fast, but I think there's also, because of Weber's phone pinging at his parents' house at 2:50.
Mm-hmm.
I think there's good reason to think it's a little slow.
Mm-hmm.
But that's what hearings are for. I mean, it's about real evidence, not cooked up stuff, not Google searches about phones.
Michael,
So
can you?
I just want to know how long she has to respond to this or to deny it, like one way or the other.
Don't they have 15 days?
I
Doesn't
think
Nick
it's
have
15,
15?
but I wanted to clarify.
Well, Nick may have 15 days to respond, but I mean, Gall could stand denied on it tomorrow.
Right.
But she has to do something with it within 15 days, correct?
No, I forget the rule. So it's not clear to me what the deal is with motions to correct error, because in criminal cases, because there's a criminal rule about motions to correct error, and then there's a trial rule about motions to correct error. And
Okay.
in the trial rule, there are a bunch of deadlines. I could pull it up. It's trial rule 59. 59. Somebody wants to go get it and read it. It's like, it's deemed denied if a hearing isn't set within 30 days. So Gall
Really?
has 30. Yeah, I think that's how it goes. It's deemed denied if she doesn't set it for a hearing within 30 days. And you obviously have 30 days to file notice of appeal from when the motion to correct error is denied or deemed denied.
Mm-hmm.
And then there are other deadlines if she sets a hearing and doesn't rule on it within 45 days or something. Anyway, there's a whole time thing, but I think it's 30 days if she doesn't set a hearing that it's over. It's kind of
So
like a pocket. It's kind of like a pocket veto, right?
right.
Now, Michael, can you confirm or explain this motion to correct error? Let's say it's denied tomorrow.
Yeah.
The appellate counsel can't and won't file an appeal based on these particular arguments, will they? These would just get
Oh, they
added.
can. Yeah. No, they can. Absolutely can. The
But they
evidence
can
is.
still file. But then they can still file their real appeal or whatever you want to say, like the big one.
Well,
Right.
I mean, this gets folded into the big one. I mean, they can work it all together however they want, but I mean, these are separate claims that are now certainly, if Gall denies it, they're right for review in the Court of Appeals. And frankly, I mean, I was talking to Kara Winicky about it a little bit. I mean, we both think that the Court of Appeals actually has the authority to send it back to Gall to actually hold a hearing on the motion to correct error.
So if they were to file, if she denies it the appeal counsel can file these particular issues with the appellate court, and then a month from now file whatever it is that would take into account the entire record. Like
No,
they
it all
don't.
goes up, no, it all goes up together. They file a notice of appeal, and then they have to choose what issues they're going to raise in the appeal. But
Okay,
all of
so
these,
until they're ready with all of their issues, they won't file anything.
no, they'll file a notice of appeal.
Yeah, but that's just a notice, right? Like what
Yeah,
happens with the notice?
right.
It
And
just
then what happens after the notice of appeal is the clerk of the Carroll County clerk gets together all the paper documents filed in the case and files a thing called notice of completion of the clerk's record. And once that's filed, the Court of Appeals has jurisdiction of the case, and it's then all on the appellate lawyers. And there's a schedule on that. Then they've got, from the time the transcript is completed, they've got 30 days to file their brief, and there'll be a few extensions on that. I think Kara thinks the Court of Appeals is going to be less generous with extensions in this case than I think they'll be, but she has more recent experience in the Court of Appeals. I try to stay out of there, and so she may be right, but case will be briefed, and who knows. And in the meantime, the appellate lawyers can actually ask the Court of Appeals to send it back for a hearing on the motion to correct error if they want to.
okay. I guess I didn't know if the appeal lawyers were allowed to like send multiple things to the judges at the appellate court. Like,
Yeah, it's not multiple things. It'll be a brief. So they'll look at the record, look, they'll look at the transcript, see what the issues are, what was preserved, what wasn't. And one reason I've said that I like the safekeeping claim in chronic so much is prejudice is presumed. It's an easy issue for the Court of Appeals to reverse on if it wants to. And without getting into the muck of all that happened in this case, they can put it all on Diener and Lesenby,
mhm,
neither of whom neither of whom is now in the positions they occupied in 2017,
mhm,
and doesn't touch Gall. And I said earlier that about a month ago, 6 weeks ago, there was a case from the Illinois appellate court, which reversed the conviction because the judge forbade the lawyer from talking to his client overnight, the defendant, because the defendant had finished his direct examination, and prosecutor didn't want the lawyer coaching him for the cross, but the judge just gave a blanket ban on the lawyer talking with his client about the case overnight. And in a relatively simple opinion, the Illinois appellate court said, that's kind of a critical stage. We're sorry, prejudice is presumed. We are constrained to reverse.
hmm,
And, look, I'm not saying that's what the Court of Appeals is going to do, but
right.
you got to give them that opportunity. I mean, right? They
So,
only, so think of it from the point of view of a Court of Appeals judge. If you're going to reverse, right? If you're going to affirm, you have to write an opinion that covers all the issues. If you're going to reverse, you only have to write an opinion on one issue.
and
And
this particular issue wouldn't be about this judge or,
yeah,
yeah,
this part,
yeah,
yeah, it wouldn't be about anybody. And it's a real easy opinion to write.
yeah. Well, and also, so what you're saying is for this particular, so for the safekeeping issue, if that's the one that they were going to consider, Let's say that's the only one they're going to consider. For
Well,
that,
the only one who's going to consider.
like it, well, if Gold denies it and it goes to the appeals court,
Uh-huh.
if they were going to consider that, when we're talking in terms of arguments that could be made in his full appeal, would this one essentially be the only one where you wouldn't have like the burden to prove that if it had gone such and such a way, then it might have affected the jury finding him guilty? Like, are you essentially arguing the procedure and the outcome of the trial doesn't really matter?
Well, for the claim regarding the safekeeping hearing, that's exactly the claim.
Yeah.
But because what the Supreme Court has said is where you're missing a lawyer at a particular point that's important enough, it is not worth the cost of trying to figure out what would have happened had there been a lawyer. Because what lawyers make all kinds of different decisions. I mean, you really can't figure it out. So yeah, that's the beauty of the chronic claim. There are very few chronic cases out there, and there's a reason. I mean, it just doesn't really happen very often that there's no lawyer at a critical stage.
So basically, they would be there would be no, they would not be going in and saying, well, yeah, he didn't have a lawyer, or he did, and they didn't tell the lawyer, and so he didn't have him present, and they weren't able to make these arguments, but he made these confessions while he was at prison, and so the jury likely would have found him guilty anyway, so we're just going to leave it the
Yeah,
way that it is. That's not even
no, it's
considered.
not. No, it's not a thing.
I
For
think
that
that's
claim.
probably a good, yeah, that's probably a good thing, that in terms of, it just seems like it would. So, and that would, if they said, yeah, now we're reversing it, would it immediately get a new trial, like right away?
Yeah. So Travis is asking, what does prejudice being presumed mean? It means you don't go into harmless error. It means you just assume that the defendant was adversely affected and the game's over.
Which is
Instead of,
essentially what we have here in the footnote, correct? I mean,
we should probably just let you read, Teresa.
no, it's good. No, I'm just saying that's. I
Well,
mean, I think that it's
well,
a different point, but same end game.
the footnote is not about prejudice. The footnote is about whether the safekeeping hearing is a critical stage, because one gloss in the Supreme Court about what a critical stage is any part of a proceeding that has serious consequences for an accused. And so what I'm trying to establish here is that we can see pretty clearly that a safekeeping proceeding
Mm-hmm.
has serious consequences for an accused. And so a safekeeping proceeding should be considered a critical stage. So if it is a critical stage and he didn't have a lawyer, we have a do-over.
It was basically a domino effect. Like, had the safekeeping situation not been handled the way that it was, then B, C, D, E, and F wouldn't have ever happened.
Also, I was just saying that to the point you guys were talking about, and this point, it's the same concept of just erring on the side that it has an adverse effect on the defendant.
Say that again, T.
Because we weren't talking about the safekeeping hearing, but we were talking about the prejudices presumed. So I was saying it's kind of like what you have here in this footnote, because it's assuming that there is harm to the defendant either way. Like that's the automatic assumption, right?
Yeah, for the claim, but what I'm saying is the footnote goes to a different question, and that
Right. I
is
just meant the same concept of prejudice is presumed.
not the same. No, it's about the serious. No, so
No.
you have to get the presumption of prejudice. you have to have a critical stage, like sentencing. Sentencing is a critical stage. You don't have a lawyer at sentencing, you're going to get a do-over of the sentencing.
Right.
You don't have a lawyer at trial, and you haven't waived your right to counsel, you're going to get a new trial. Here's a good example. You have a lawyer at trial with an actual conflict of interest, right?
Okay.
You can show the actual conflict of interest. It's an instant trial. You don't look into like whether the conflict affected his representation or not.
It just is
But
what it is.
what?
Like, because it exists, period.
Yeah, it's over. But
Yeah.
you have to. So we all know the trial itself is a critical stage. But for instance, a lineup is a critical stage.
Hmm.
If you've been arrested and you're put in a lineup, you have a right to counsel at the lineup. And so there are other proceedings at which there's a critical stage. And by the way, it's a really interesting. I've raised it as a problem with certain authorities, but the motion to correct error stage of trial of a criminal proceeding is almost certainly a critical stage. And by local rule, after the sentencing in Carroll County, public defenders are deemed withdrawn from the case. So what the local rule does, it strips defendants of lawyers during the motion to correct error phase.
Because the appeals lawyers, even if they're appointed, they won't file this.
Not usually. I
Okay.
mean,
So
look at it this way. Look at it this way. The appellate lawyers don't really even know the case yet. They don't have the transcript. You
I
all,
know, it's
and
crazy.
I don't feel like I know the case. You all have been living this case for I don't know how many. I mean, different people, different times. I've been with this case for a year. I got into it on the contempt stuff, getting in on the contempt stuff to defend Brad and Andy. Sort of got me hooked into some of the facts, and I sort of in May I really started. I tried to help them out with some of the IT stuff. I mean, I was their IT consultant for a short. But obviously I've gotten farther into the facts, but boy, I still don't know the facts like any number of you
And the appeal people know even less.
people. All I can do is quote Brad Rosie to Judge Gall, but directed at the appellate lawyers. You
You
don't know this case.
don't know anything about this case.
this whole court is out of order. So, so I clicked on the comment and made it go away, of course, which I didn't want to do. Somebody was asking, so if the safekeeping is deemed a critical stage, and does that, and I don't know the question verbatim anymore, but does it essentially roll down to fruit of the poisonous tree with the confessions and anything that happened at the IDOC?
That's an interesting question. It might be made at a second trial. I saw that question in the chat. I, I
There
think
should
you're
be.
going
There
to have
should be a heavy consequence for this, in my opinion.
well, except that I think you can say, I think, look, let me make the argument on the other side. So there's a doctrine of attenuation. That is to say, if something, the result of a confession is the result of some illegality, maybe the safekeeping hearing thing was illegal, but it wasn't. It was the DOC that put him in solitary. There's no reason, just the illegality of the safekeeping order itself. It was really the DOC that did it, not the safekeeping order. But that leads to another argument about, and it was kind of the argument I think Brad Roseanne was making, that you kind of had coerced confessions here. Again, I've never been a big fan of the coerced confession thing. The involuntary confession thing I like a lot, but I see the coerced confession argument.
Mm-hmm. Mm-hmm.
But I'm just saying, look, you've got a colorful argument. You make the record, and I mean, especially where the argument gets you so much, like excluding the confession. And one reason you make the argument about the safekeeping hearing, because if it's succeeds, you get a new trial, and you get a new trial without showing a prejudice. And it's the same reason that you raised the ban thing about the state knowing use of false evidence that it didn't correct,
Mm-hmm.
because you don't look at all the confessions and stuff. It's not harmless error. The question is whether the evidence could have affected the verdict. Well, we know it could have affected the verdict. McClellan was making that specific argument in closing.
Mm-hmm.
So the confessions just go away.
I guess they could say, well, the order and the motion for the order did not request that he be put in solitary confinement, just that he be put at IDOC. Or actually, I almost think it
But he
didn't
wouldn't
even
have been
specify
in
that.
solitary confinement if he wasn't at IDOC. I mean, so it continues on. You just have to. I don't know if
Well,
you can actually.
I think he was in solitary. Like, I think he would have, even at the jail, he was in solitary confinement. Right? I'm pretty sure. I think he was always by himself.
I don't know. I don't
I don't
recall.
know. I do think that there was coercion here in the sense that I think that I think conditions were made in order to even things down to, like I said, he was stopped from seeing his wife, who's like the only visitor that I'm sure he would have had any
That's
need or want to see. And then, like, as a reward for making these statements, then he's allowed to see her. It's conditioning.
Can I go back to the local rule from Second Travis in the chat has a
Removing
thing.
them, they get removed right away.
Well, Travis has a thing that says technically when the appellate lawyers were appointed, Rick was without counsel, therefore deprived of counsel at a critical stage. No, and I want to answer that. It's the appellate lawyers. They may be listed on the docket, on the trial docket. They don't have appearances in the trial court.
Mm-hmm.
And so until Brad, Andy, and Jennifer filed their limited appearances yesterday, even with the appointment of the appellate lawyers, was without counsel in the trial court.
Yeah.
So it wasn't. It wasn't. So the appointment of the appellate lawyers had nothing to do with Rick's representation in the trial court, and the reason, because of the local rule about removing lawyers, that's why we kind of figured out that Brad, Andy, and Jennifer had to file a new appearance, because you didn't want on the last day Gall to be able to say, well, you don't represent him. You don't have appearances on file.
Mm-hmm.
Um, you were out of here because of the local rules. So this motion to correct error is nothing, and I'm striking it.
It seems bizarre to have that rule when there's still a motion that is like,
The rule is crazy. The rule is crazy.
yeah, because I would think it's expected to be
It doesn't make
filed. It
sense.
just
Yeah.
doesn't make sense.
So the rule should be, um, you know, public defenders or appointed counsel are deemed withdrawn when a notice of appeal is filed, when
Yeah.
the time for filing a motion to correct error has, or notice of appeal has expired,
Definitely.
or when, yeah, I mean, there's a way to word the rule so that it actually works without depriving people of their public defenders at a critical stage.
I mean, not for nothing, but they let Krebin stay on the docket as an attorney on there for like a year. Like, for what? You know, and he filed one motion and they let him stay on there for a year. A motion for something that was already happening. But they're sentencing and these guys get the boot right away because of a local rule? That seems strange. Whatever.
Okay.
Travis is also asking whether, I think he's asking who handles appeals on the state side, and the answer is that the AG's office handles all the appeals.
Yeah, Nick's telling everybody that. That basically the AG's office takes care of everything. We're just in a support role. But like he would be
Let's
the
go
one
back to
responsible.
retrial. He's retrying the case.
Yeah. Well, yeah, and this particular thing, if he was going to respond, this is his, like, he's not done. He would have to respond to the AG's office won't respond to this if he's going to do a response.
So, Travis, I want to answer Travis again. It says Rick had no counsel for 10 days until yesterday. No, Rick had no counsel for 30 days until yesterday. After the sentencing, their appearance, I don't know when they actually disappeared from the docket, but under the local rule, their appearances were deemed withdrawn after the sentencing. And until they showed up yesterday, he had no lawyer in the trial court.
And that's
What age are we
normal.
on, too?
Anna?
Yes, according to the local rule in Carroll County.
Right, that's what I was wondering.
Yeah, and I don't know whether that local rule exists anywhere else. I've never seen it before. It seems crazy to me.
Now we need to check all the local everythings and find out.
Okay, let's get back to this then. I think we pretty much covered most of this down here now. Because we talked about the footnote already. Okay, so in either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. Which I'm be surprised she does either one, but that's just me. So, in violation of the Due Process Clause of the 14th Amendment, hold on, I have a hair in my mouth. The state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing that that testimony was false before it was elicited or failing to correct it once it had been elicited. A conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it does appear. At trial, the undisputed evidence was that Libby's cell phone stopped moving at 2:18 on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McClellan called it a hard fact, quote unquote, that LG's phone stopped moving at 2:32 p.m. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Wallace stated Mr. Allen said he had abducted LG and AW on the south side of the Monon High Bridge and forced them down the hill to the south side of Deer Creek. Dr. Wallace said that Mr. Allen said he was on the south side of Deer Creek and was planning on sexually assaulting LG and AW when he was interrupted by a van. Dr. Wallace said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Weber property to Ron Logan's property, taking Libby and Abby with him. The state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13th and arrived home in his white cargo van at about 2:30. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take Libby and Abby across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at about 2:30 was a detail only the killer would know, said the state. I fucking hate that. This is so stupid. But the problem is the state also contended that LG and AW died near in time to 2:32 p.m. when Apple Health data from Libby's phone showed that the phone stopped moving. If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Allen would have had to have arrived near his parents' house at the end of the private drive before 2:32 p.m., when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:54 p.m. on February 13th. His arrival at about 2:30 could not have been a detail only the killer would know because it did not happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. I want to talk, I'll finish reading this, then we'll talk about it. Okay, so Defendant's Exhibit 3A, as attested to by Matt Hoffman in the Defendant's Exhibit 3, is a video recording made on February 13th by a security camera that was in the house at 5998 West County Road 252. The video recording was provided to the defense by the state and has therefore been in the state's possession. The security camera faced northwest, and appears to have recorded continuously. Based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video at the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on West 252 North and County Road North 625 West, and the beginning of the private drive to the Weber property, which begins as a continuation of North 625 West, approximately 190 feet north of that road's intersection with West 252 North. County roads, I'll show you guys this on the map because it can be kind of confusing if you're not actually looking at it, are the only roads by which a vehicle could enter the Weber property. According to the time and date stamps on the security camera recording, Exhibit A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44 and 33 seconds p.m. on February 13th. Exhibit 3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44. Exhibit 3A is viewable on YouTube at the following address. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording that is Exhibit 3A. Each successive clip in Exhibit 3B is zoomed to a greater magnification. Exhibit 3 and all 3 zoomed clips of Exhibit 3B, a white cargo van going north on North 625 West just after 2:44 on February 13th. Exhibit 3B is viewable on YouTube at the following address. And then Exhibit 3C is the photographs taken from that exhibit, from that video. Zoom level 1, zoom level 2, zoom level 3. There are 3 still showing the white cargo van. Okay. Let me show you guys these in case you guys haven't seen them yet. And I'll also show you on the map. But Michael, so this seems to be a point of argument on the social medias. So can you clarify why this would be important to put in here? And if it's in discovery, that would mean that the defense had it. And why would it not be brought up as rebuttal or cross-examination during the trial?
Well, I don't know why it wouldn't. I don't know why they didn't bring it up. Maybe they didn't think of it. But the point about this sort of claim is that whether the defense brings it up or not, the duty is on the prosecution, the state, to correct false evidence, regardless of what the defense can do. If they knew or should have known that Weber's testimony was false, they should have corrected it. And it has nothing. That's another reason you raise this issue, because not only does it have a great prejudice standard for the defendant, the duty's on the state.
And recently, with the Lamar thing, Nick has shown that quite literally he has done exactly what this says. He had the body cam footage of Lamar And yet he allowed Lamar to, at a bench trial, lie, despite knowing that the body cam footage that he was going to show showed that what Lamar was saying on the stand was untrue. And he got called out for it by the judge in the order. So, not for nothing, I'm not buying that the state didn't know that they had this evidence. Well, I guess it doesn't matter. We'll see what they say. Maybe they'll say that they thought this was close enough in time since Weber said about 2:30 or whatever. I don't know. I don't know what explanation you would have, but it would seem purposely left out for the exact reason that this motion says. That basically, if it was at 2:44 and not 2:25, which happened to be perfect timing to be driving down the private drive for the phone to start moving again because he was scared and made them move, is why it
Look,
wasn't brought up.
if you go, so I haven't seen the transcript, but
Right.
if you listen to Andrea Burkhart's live about closing argument, she reports that Nick McClellan said in closing argument, talking about Weber and how that evidence was developed. He said Steve Mullen went back and saw there was a 2017 interview with Brad Weber that mentioned a van. So we started looking into it, and it turned out, yes, Brad Weber had a van, a white van. And sort of it all goes downhill from there. So what we have from that is Steve Mullen is looking at the evidence related to the van. Like, you're not looking at this video. I mean, there's some evidence there that they knew or should have known, they actually knew or should have known about this video.
Didn't Mullen say that, or maybe it was Weber that said, but maybe Mullen confirmed that when he brought Weber in to talk about all of this in August of 2024, which is after the trial was supposed to have originally happened twice, that Weber brought in like text messages to show that he was driving the van and when he was driving the van and stuff like that?
I don't know that he said that he brought in text messages. I think he
Or
said
he
at
looked
least
at
that he looked at them to reconstruct the thing. And I'm I'm not going to go there for now.
So my whole point was just to clarify to anybody who thinks that the defense should have brought this up, that legally they don't have to be the one that rebuts it in court because it was happening during Nick's testimony or Nick's direct.
Nick should have known that it was.
So the argument is, and it's not an argument that has to necessarily be accepted, but the argument is that because the if the prosecution doesn't know that Weber's testimony is false, they don't have a duty to bring it up. They don't know. So, the argument is because they had this video, they knew or should have known
that the narrative they were putting out was false.
Yeah, and they didn't correct it. And so the other thing about this, though, is you'll see at the end of this, there's this thing where it says so the court says that the court thinks that this, isn't evidence that the state either knew about or should necessarily have known about, then it's newly discovered evidence. And the reason you put that in there is if the state didn't know about it or shouldn't have known about it, then the defense shouldn't necessarily have known about it. So with respect to the defense, it's newly discovered evidence if the state is not held to having known about it.
Got it.
Good thinking. I remember reading that, but I guess I wasn't, when I read that it said newly, all the things you just said, that if she's not going to say that the state knew or should have known, let's say they say, we didn't know that existed, Okay, that's fine. Well, then it's newly discovered evidence because we got this from you. If you didn't know about it or shouldn't have known about it, then why should we have?
Yeah, that's exactly right.
Right. Perfect. Thank you. I'm glad you clarified that, because that's one of the biggest things I've seen across social media today as this has come out.
But
So
Well,
for visual
Michael.
purposes, I just want to show everybody where we're talking about, and then we'll look at the videos. But here's the bridge, here's the cemetery, here's 300 North where the Hoosier Harvest Store camera is. So 625 and 252 is the road where Abby's house is actually off of 625. And then it goes straight up to where Teresa sees the unknown man. Teresa Liebert sees the unknown man in the morning. And then the private drive starts right about here, and then it goes up and around. And if you guys have watched where we went through all the steps and everything else, you guys are going to know. So it goes straight up here. It goes right underneath the bridge on the south side, and then it comes around into the Weber's property. And then here's like the Weber's barn that we talked a lot about. So
I'm not looking at the screen right now, but if Lucy can pull up Exhibit 3, which is Matt Hoffman's affidavit, there's a Google Earth diagram there with the house circled where the security room was.
yeah, I have. Yeah, I'll pull it up. So I have, here's the house. It's ironic. It's actually the Sandifer house. And if anybody's been around the case for a while, you guys know who the Sandifers are. So this is the location of where the camera is, and it's facing this direction, facing the northwest. So I just wanted to be able to show you guys that visually, so you can see what we're looking at when we look at the video.
But Michael, while she's pulling up that, are you going to pull up the minute one? That's the 3 zoomed one.
I can, yeah.
But before we get to that, just since you explained that whole thing just now about the state knew or should have known, if they didn't, then it's newly discovered evidence. Does that same argument apply to the Ron Logan stuff?
No, the Ron Logan stuff is different. The Ron Logan stuff is it
Newly
wasn't used.
relevant, basically.
Yeah, I mean, Dr. Core comes up and says box cutters, and immediately we got Ron Logan having confessed using box cutters. I mean, they didn't use the word nexus in the motion, but boy, that's a nexus. And
Just don't let me forget when we get there, because the question that I'm seeing everywhere is essentially, I think people get the whole idea that it became newly relevant when he mentioned the box cutter thing at trial. But I think what's getting people lost, some people, is the defense. Why didn't they bring this up when he was testifying at trial? And I think that it probably is a mix of, or why didn't they try to bring it up? And I think I should preface by saying we don't know what they tried to bring up and what she didn't allow them to bring up.
Right, and so you set it up, and if a court says, nah, it's not newly discovered evidence, that sets up other claims. I mean, you really are trying to set things up for now and for later.
Yeah.
It's kind of what I do. It's set cases up. I don't win them so much like that. I mean, I consult with the state PD's office and a bunch of people about how to set cases up.
I think this is brilliant. I think in terms of evidence that's like hard to deny, I guess, the zoomed in video. I mean, I am one of those, I've said it before, I'm one of those sleuths that, like, I'm not one of the ones that I organize data. I'm not one of the ones that will sit there and like zoom in and mess around with the contrast and the this and that to be able to see things in the background of certain things. I'm not like, I hardly ever see anything. But that zoomed in 1 minute thing, I mean, to me, it was clearly a white van. Like when I saw it, it was like, oh
nobody else
shit.
should be going back here on this private property. that is theirs, and it happens to be a white van. But I do think it's interesting because he, and I don't remember which one was which, but he told either the agent or maybe it was Hammond. I don't remember which one was which. So just either way. But and during one of his interviews, he stated that he was actually driving his Subaru. And in the other interview, he states that he was driving his white van. And this was within days of the murders.
Well, I mean, the simple fact of the matter is that whether he's driving it or not, someone's driving that white van down the private drive.
Correct.
At that time. So
either
there's another witness.
Why is the assumption from the automatic ragers that this time has to be wrong? Why? What's the indication that the time is wrong?
Because the defense filed this.
That's it?
Mm-hmm.
No, the
it's funny because people didn't.
It says 02. It says 02. So it's not. It's clearly 12 hours behind.
Folks, I understand, but I'm just saying that they're saying that even with that no, it's off by more like minutes based on the fact that he was there at 2:30. So this must be off by 14 minutes or whatever.
No, it's not. It's not. And look at and if you look at the FBI subject information sheet for Weber, which is 3E. It says the phone. It says the phone pings at 2:50. So if you're gonna, if it's an error, it's slow, not fast. Now there is some reason, or there is some reason out there to think that it might be a little fast, but not fast enough to get it there. Not fast enough to get there before 2:32.
Yeah. So regardless, it happened after the phone stopped moving and after the state says that the girls were dead and Abby was laying on top of that phone.
On any version of the thing, Weber could not have arrived in time to drive anybody, much less Rick Allen, across the river between 2:25 and 2:30, across the creek between 2:25 and 2:32. Period. The end.
It's funny. I don't hear them. I never heard them really questioning the Hoosier Harvest Store camera, like the timestamp on it.
Well, then we knew it was wrong.
But how did we know it was wrong?
Well, I mean, we were told it was wrong, I should say. So they didn't have to question it because they were told it was wrong. But they never questioned whether the time they were told was wrong was not still wrong, like they're doing with this.
They haven't even seen the Hoosier Harvest Store footage. They've seen more footage here.
Look, but let them look. We have put this evidence in. It's out of the state's file. We think this is why people have hearings. Yeah. If the state wants to come in and prove that, it's 15 minutes fast, let them try and prove it. That's why you have hearings.
But if they don't, then the appeals court is going to assume that it's correct. Hey, Michael, what if she's inclined to deny it, but Nick also requests a hearing on this? Can she still deny it?
Absolutely.
Okay. So she could say, I don't care if you both want a hearing, I'm not having one.
Yeah, you can.
So what if he responds? What if he responds with arguments back and she still denies it? Will the appeal court still consider everything in the defense motion to be the truth?
That's an interesting question, and I've never seen that happen.
Okay.
That they do consider it the truth, or you've never seen them consider it?
I've never seen a response, at least on factual stuff, filed, and then there's not a hearing.
Well, Goal is a trendsetter for weird shit that never happens. So.
And my best guess is that in that situation, if McClellan filed a response that contained actual factual stuff, and then Gold denied it all without a hearing, my guess is the Court of Appeals might really send it back for a hearing.
So they wouldn't just consider both arguments and make their own finding?
Don't know. It's a really good question. I really don't know the answer. That's one thing that's one thing I'm happy to do is confess that I don't know answers to things.
Is this the footage? Is this the 1 minute one?
This is
Oh,
the
this
1
is
minute.
such a good video, Michael.
It is. It's such a good video. So for anybody who hasn't seen this yet, if you're watching it here, you're paying attention towards the left side of the screen where the white van will come in, and this is a zoomed in one. So there is the one that's further back, and I'll show you guys that just real quick so you can see it. So you can see it further back as the camera is set at the house. So it's zoomed in. You can see like Teresa Liebert's. You can see the neighbor. You can see all the area. So this would be 252 kind of running at an angle this way. And then you have the road that Abby lives on running this way. So kind of at an angle. You're looking at it.
That's 625. What you're pointing at right now.
625 is this way.
Which way?
This way.
Yeah, I thought you just said the opposite.
No, that's 252. So this is the zoom. I just wanted to show them the outside, like the original view before we zoomed in on it.
What you're essentially seeing is the white van getting to the end of 625 and going down the private drive, which is also, I guess, considered 625.
Right.
But it's the private drive.
Right. Okay, so I'll play it. It doesn't have sound, so if you don't hear anything, there's just no sound. So you should just be paying attention. Like right here, you can see. You probably have to zoom in, and if you're on your phone, you can zoom in. I can't zoom in any further on my computer, but you can see the van going.
It'll zoom in 2 more times. So it'll show you it, and then if you don't see it, it'll zoom in. You'll definitely see it. But there's on your mouse is where it's at.
Yeah.
But when it zooms in this next time, you'll see it for sure. I mean, you can't miss it.
Remember, so in the filing it says zoom 1, zoom 2, zoom 3, or ABC, something like that.
Yeah, it'll zoom in. There you go.
There you go. So for people who are like, I did see one comment under one of your videos, Michael, that's like, ooh, there's a ghost van that drives through buildings. I thought that was I almost responded, but then I was like, I'm not going to start a fight.
What?
Yeah. So I was like, I'll just address it when we go live tonight. These items that people think that the van is driving through are in the forefront of the frame. Just like every video you ever watch.
Jesus Christ.
Nobody's driving through them.
No, they're in the background. No, those are in the back. Those are in the background.
Some are in the forefront.
Yeah, it looks like a carport.
They're both on the west. Both of those buildings are on the west side.
Not the buildings, the items. Yeah, here, look. So like this is a tree. Let me go to the other one. I'll show you. I don't know if I can do it on my phone, but I can't do it on my computer. So there's like the trees and things that are in the front, and then there's the housing is on the back. I'll go back to the maps. So you can see what the buildings are all on this side. There is no housing on this side. So you see the van driving up here, right?
Mm-hmm.
But like there's trees. There's no houses over here. It's all trees in the forefront.
Yeah, but it's the buildings.
I know, but the van is driving through buildings.
It's the buildings farther south on 625.
It's Haas's house, is it not? Because if the camera's pointing northeast, it has to be Haas's and Liebert's.
Yeah, I guess that's right.
That one that your hand was just
It has to be these houses.
Yeah, that's what I assumed.
Otherwise, it's just pointing west.
No, it's pointing northwest.
Right, this way.
I mean,
stupid ass street names.
I'm sorry, it's pointing west northwest.
West, yeah, pointing west northwest.
Good
right,
Lord.
so it has to be these houses, but they're all on the left anyway, so it doesn't matter.
Right, and the van clearly passes in front of them, and I love the people. I love the people who question something just zoomed in versus the bridge guy video that was which has clearly been doctored and it's like, oh, that's the guy. And
That's great,
then
right? They
where
can
he
even
was.
see his mustache, right?
Well,
On the,
to me, it's the tree growing up out of the platform, and there's no tree anywhere near that platform.
Oh yeah, we
I
went through
mean,
that.
you're a real Diggleberry if you're sitting here not saying that this is quite clearly a white van headed down the private drive exactly where the person said that they were driving and what they were driving around the same time. We're only talking a matter of like 12 minutes. The only reason there is to deny that this is a white van heading down the private drive is because you don't like the timestamp, because it means it was after the phone stopped moving.
And by the way, the defense has good reason to believe. Not going to talk about what the reason is, but the defense has really good reason to believe that Weber did not leave the parking lot of the Subaru plant until almost 2:11.
So it would also
You
make
might.
it. I'm sorry, but this timing is more. This timing makes more sense in the distance of Subaru to begin with, let alone if he didn't leave it until 2:11 or whatever. It didn't make sense for him to be home in 20 minutes if he left at 2:02 in order to just be there before the phone started moving again. You know what I mean?
Well, I
You,
agree.
yeah,
This just makes more sense.
yeah, it makes a lot of sense.
I feel like next incoming, Cecil's gonna run another report on Libby's phone, and we're gonna find out that oh, we originally thought that the phone stopped moving forever at 2:32, but we just ran it on updated software, and now it was 2:52. It was just off a little bit. We found new data. Um,
Oh, they just changed the whole timeline of the crime.
same thing with the whole
I
once they found out
Googled
about the text
through
messages.
some Apple forums that there's a possibility that with the water damage, it could set the phone back approximately 20
Yeah.
minutes.
First the
Yeah, here's
phone
why.
was dead, then it wasn't dead.
No, here's why Cecil isn't going to be able to do that, and that's the Apple Health data. That's
No,
the
I know.
Apple Health
I
data.
was so
He'll
joking.
say she got a text message or something and it pinged over on the other side of the creek.
Well, that kind of does in. Um,
Every time he reruns the report, Michael, it's to combat something that's filed by the defense, is what I'm getting at. The phone was
yeah,
dead all along until that 440 whatever flood of text messages happened, and then all of a sudden it wasn't dead. It didn't die till
4
right after that.
4:33 a.m.
Yes. I'm sitting here cutting balloons out of paper.
But for years, it was dead.
Yeah.
It was dead, dead. Okay, let me see.
Well, and for years, it was two blades, one serrated, one straight, and then at trial, it
Yeah.
became box cutter.
Nick, you will rue the day that you said that it was a box cutter. Because
Okay,
now
so
we're
let's.
bringing Ron back from the grave.
We haven't got. Yeah, we haven't got to. Yeah, God, we haven't got to Ron yet. Oh shit. Okay.
Oh, that is so good. Let me shut up because
Okay,
that
hold
was
on. Well, I
really
don't know if I need to read all of this because I think we essentially just went through all of this. So I'm just trying to go through and see if I actually need to read any of it or not.
Probably not. The point of it,
the final one.
the entire point of it's actually pretty simple, and that is that in closing argument, McClelland said that um, sometime between 2:25 and 2:32 when the phone starts moving at 2:25. So Rick or whomever is interrupted uh, by a van going by and takes the girls across the street. Van has to arrive before 2:32 when the phone stops moving. No van arrived before 2:32. It didn't.
You're probably good to read like the last two little paragraphs before it goes to the, like, it sums up
Yeah, I'll
basically
do that.
that,
But
yeah,
you
that
guys,
basically,
before we head off of the van, I want everybody to know that I have a personal issue with this whole van theory. I have since the day that it came out in testimony. It pisses me off. This is not something that only the killer would know. This is nonsense created by YouTube jargon. That's where I'm so frustrated about the van. I always have been.
well, and the
Okay,
fact of the matter is the van, now we know the van was there. Like the rumors were true. There was a van. The problem is it was closer to 3 o'clock and it was after Libby's phone stopped moving. And you can't, like, now after you've got a conviction, change what theory, like, you convicted him on. You presented the evidence. You said that evidence that her phone stopping moving at 2:32 means she died then, right?
right.
So you can't now say, well, maybe she didn't die at 2:32. Maybe she didn't die until 2:52. You can't just say that.
That's what they do, though. They just say it, and then it's like, oh yeah, well they said it, so that must be it.
It's not really related to this, but there's another white van in this story.
There's 4 white vans.
We know.
There's 4 total white vans in this story that I know of.
Well, the one I'm thinking of is the one that is extremely suspiciously parked outside the Packers
Packers. Yeah.
on
Driving by
100.
Packers.
No, it's not driving by. It just sits there for an hour. So it's parked by the side of the road on a very narrow road. Nobody gets in and out of it for an hour and 50 minutes.
It was in
Uh,
that building company, the construction people's, Tracy, I know you know what it is. The one where they
I
did
do.
like the time lapse of the construction.
Hmm.
It's in that, on that road.
Yeah, I have the photos.
it's on 100 just off of 421. It's really hard to figure out why a white van is sitting there parked for an hour and 50 minutes with nobody getting in or out of it. There is a car that goes by, but this van doesn't pull out. It leaves after that car, but it's certainly long enough afterwards. It's not like it was waiting for that car to come by and then follows it.
And someone
Um,
had to have been sitting in it the whole time. But was there ever footage of someone getting in or pulling up?
no,
Was
there
it
is
a
no.
cargo van or a
I
transit
don't.
van?
Cargo van. I'm pretty sure.
Okay, so there's a transit van that drives by the Packers plant that I have the photos of. There's also the white van that was spotted that was attempting to kidnap children about a half hour away. Then
Yeah.
there's a light gray, almost white van that's parked at the cemetery.
Yeah. Did they say that was crime scene people?
They did it. Nobody's ever been 100%, but people have said that it could be crime scene people. But we also know that there were cars parked there from the searchers, so nobody's been ever been able to prove or come forward and said, yeah, that is, um, a
Specifically.
crime scene van or a LE van.
Yeah.
So because that's where some of the searchers were parked, like what's his name?
Brown.
Can I address something that Miku's headphones, that phone stopping does not prove time of death. I absolutely agree. But
That's bizarre.
Cleveland's argument was, and in his rebuttal was that
It did.
the girls died close to the time of the phone stopping moving, and that at 2:32 when it stops moving, or shortly thereafter, Abby, as she's dying, hides the phone under herself.
Yes.
So I'm not. We're not talking about the phones proving time of death, but McClelland clearly ties the time of death to the phone stopping moving.
Correct.
Me as a juror, if that was what he was presenting to me, I would agree with you. But for the purposes of this motion, Well, and he said that that was hard data. Not sure how but he makes quite a few assertions that I'm not sure how he got there either. So it's,
But this whole hide the phone thing is new. They always called Libby the hero for recording Bridge Guy. Libby was always the hero. Abby wasn't a hero until trial.
well, because he needed to explain why a killer would move them and whatnot and leave the phone.
But his own expert Cicero clearly stated that she just died on top of the phone.
Right, but she was scared. So she was scared. She was hiding the phone, and then she was killed. And the killer didn't know that the phone was. That's what he's saying, is that Richard Allen didn't know that the phone was under Abby, or he would have taken it. And he obviously doesn't have any evidence that would say that. I mean, unless you're going to consider the Ron Logan stuff.
All right, let's get to the Ron Logan stuff. Let's talk about that. Okay, so to finish off with the van, so to obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of the murders that might be true. The state, therefore, cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an quote-unquote effect on the outcome of the trial. Alternatively, where the court defined that the state did not know or should not necessarily have known about the camera, and Exhibit 3E, which is the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. So anything you want to talk about with the van or any of that and why it was important to put in here? Anything you guys want to add before we move on to Ron Logan?
Nope. There are things with the Ron stuff that I've deciphered that I'll pipe up about, but I think the van's pretty much well covered.
Okay. So Ron Logan's confession to, is it Richie? Ricky?
Reese.
Reese?
Yeah, like a Reese.
Reese Davis, like a Reese cup.
Okay. Ron Logan's confession to Reese Davis before May 15, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. So Dr. Core was the forensic pathologist who conducted the autopsies of Libby and Abby. His original opinion, held for years about how Libby and Abby died, was that two weapons were used. One a serrated blade and the other a straight edge blade. For the first time at trial, having had a eureka moment at his tool bench, Dr. Core opined that the girls, it's just funny, a eureka moment, opined that the girls could have been killed by a single box cutter rather than two different knives. Defendant's Exhibit 4A, as attested by Matthew Hoffman, is a redacted copy of a tip from the Orion database of tips dated May 15, 2017. And in that tip, which the state has always had, Ron Logan is alleged to have confessed to Reese Davis sometime before May 15, 2017, while they were in prison together, that he had killed Libby and Abby. The material part of Ron Logan's confession to Reese Davis, as it appears, is reproduced below. So Logan confessed to Reese step by step of killing the two girls. Logan told Reese how he burned his clothes in a fire pit and where it was located, used box cutters and struggled with one of the girls, and thought drops of blood from his nose ended up on her clothes. Reese also advised that he killed the older girl first. So Reese Davis was not his cellmate, correct? He's James Haas was the cellmate, and Reese was somebody who was on the same cell block.
Same pod.
Same pod. Okay, so because James Haas is the one that I think most people are familiar with, that Ron Logan had confessed to James Haas when he was like laying naked on his floor.
Mm-hmm.
You guys, I don't know if everybody remembers that. So, and then Reese Davis this one's this is newer for me anyway. I don't know. Have you guys ever heard this prior to now?
Mm-mm.
I don't remember this one being a big thing that I ever looked at, or because I even think with it. So the defense at one point before trial had requested transfer orders for Keegan Klein, James Chadwell, Reese
Haas.
Davis, and James Haas. And I, in my memory bank, I recall knowing the three, obviously, and then not understanding who this Reese Davis person was. That's why in my memory bank. So I'm just going from that. But we knew at the time that they all had to do with confessions, and if multiple people confess to the same crime, then why couldn't we say that there were false confessions? So we had Ron Logan who'd confessed, we'd had James Chadwell who'd confessed, we'd had Keegan Klein who'd confessed and blamed his dad, and then we also had Elvis Fields, but that was a different third party situation. So this is interesting. So he tells not somebody who is in his cell, somebody who's on his cell block, and he tells them details about what he did.
Mm-hmm.
So Ron Logan, go ahead.
And it should be known that Reese was in prison already when the crimes happened. So it's not like he was out searching and hearing all the things and stumbled across something to get details. Like, he was in prison and didn't know any of these people. Like, there's details here that he wasn't living around these people all the time. You know what I'm saying?
No, I don't know what you're saying.
So he wasn't like out. He didn't pick up the buzz around town the minute that it happened because he was in prison. So some details, like Ron knowing one of the girls' mom worked at a bar.
Well, he knew. He knew that.
Yes, but what I'm saying is he didn't know it from being around town.
But he wasn't arrested for over a month. Almost a month.
Reese was arrested. He was there for years.
We're talking about Reese. I thought you were talking about Ron. That's why I was like, what?
I'm saying he knew details that he wouldn't know unless Ron told him.
I got you now. Because I was like, I thought you were talking about Ron the whole time. That's why I was like, what? Like, yeah, I'm confused. Yes, Reese knows details that he shouldn't know because he was locked up already.
Yes.
Got it. Okay, so Ron Logan's confession to Davis, as reflected in the tip in the Orion database, and it made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matthew Hoffman, is Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant Hansard. He's a new player. About his interview with Reese Davis on June 21st, 2017 at the Newcastle Correctional Facility regarding Ron Logan's confession to Reese Davis. Those handwritten notes of First Sergeant Hansard are attached to ISP Detective Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Reese Davis about Ron Logan's confession provide even more detail. Go ahead, what?
Said he should be arrested for his horrendous handwriting.
Oh, this is pretty bad. You should be able to read it though.
Yeah, I already been through it. I got most of it, but I still stand.
Hard as they are to decipher.
It's criminal.
And subject to debate and correction, those notes reveal the following about Ron Logan's confession to Reese Davis. Okay, so talking about knowing one of their, it seems to say talking one of their dads.
Yeah.
Oh, I can see that. Okay, but I probably shouldn't look down there yet. How do you have this? Did you already look down here and go through that?
Yeah, but and then this says volunteered voluntarily
with him.
walk with
Walk
him.
with him.
One of them wanted to turn around. Walk with
Grabbed
him.
youngest shoulder and said, "It's okay."
Yeah.
Oldest freaked out,
Uh-huh.
got paranoid and grabbed her.
Yeah.
One said something about calling police.
Uh-huh.
Sexual attack wasn't
True.
something originally. Wasn't true originally.
Not trying to go rape them.
Not trying to go rape them. Paranoid about probation.
Mm-hmm.
Felt like he crossed the line when he grabbed the youngest one.
Yep. Next.
Okay, so did a pretty good job deciphering that one. Okay. He started talking. Ironic. Should have been in school.
Uh-huh.
Talking to them, knew one of their moms worked at a bar.
Uh-huh.
Animals walked with them.
Uh-huh.
Willing to go check out horses.
And
He
maybe says or said he told them
he had
he had
rabbits,
rabbits in barn.
Walk through trail in weeds. Oldest paranoid.
In woods. Walk through trail
Walk through trail in woods. Okay, woods, weeds.
Oldest
Okay.
paranoid. Didn't want to go. No, oldest paranoid didn't want
Don't want to go.
go.
Don't want to go. Youngest wanted to see horses.
Uh-huh. Now, didn't Abby like to ride horses? Didn't she do that with her grandfather?
Mm-hmm.
So it wouldn't be unusual if she would take an interest in horses, probably.
And also, well, Abby's also he knows Anna.
Right. Well, isn't that what a predator usually says? I know your mom, I know your dad. They told me to come see you. Like, you know what I mean? Isn't that what we're taught? Like, don't go with anyone, even if they say they know me.
Unless she knows that he knows her mom.
No, he probably did know her mom. I'm just saying.
What if Abby knows that he knows her mom?
Well,
what if she sees her mom say hi to him or whatever?
Could be. Could be. I'm just saying that generally bad people.
Yeah.
Because kids are dumb. And they find comfort in you saying, I know your mom.
Right.
Even better if you could tell them your mom's name. You know what I mean? Like, they don't.
He does know her mom. Well, they also don't live very far apart.
Right.
I mean, Abby lives right there.
Right. Oh, true. Like, literally a stone's throw.
Right.
All right, continue. You're doing good.
Oldest, something to help youngest.
Tried to help youngest.
Oldest started walking.
Oh, yeah, maybe talking. It is walking.
Could be talking or walking. Youngest
seemed. This is horrendous.
Yeah, I don't know that one at all. It's C8 or SHR. I don't know. Okay, he now grabs oldest. He said, he got hit on nose. Something
scared. He got
scared. He got blood on one of the girls.
Mm-hmm.
Pulled box cutter out. Slit oldest one. Hit an artery.
Mm-hmm.
Youngest scared, etc. Took little
girl.
Something little girl with him for a while, never said where. Oh shit. Okay. He said he cut her to cut both necks.
I think that's meant to be like TOO, but he was
Yeah, cut her to
yeah.
and cut both necks. So there's something up here that I don't started
Where?
walking, talking, and youngest seemed something. I don't know. Let me see what they said. Youngest seemed okay. They don't know what that one is either. Oldest turned to help the youngest. Oldest started looking, kicking.
Kicking. I like kicking. I liked walking.
I don't know.
Where you at?
Okay. But he pulls out a box cutter and kills the oldest one and takes the youngest one with him.
Doesn't say where.
Shit.
But someone brought up a really good point about
Struggling.
Someone brought up a really good point about the like why one girl, particularly Libby, was naked, potentially being that he thought he had blood on one of them. Oh, and I'm hearing people say like, well, he said this, but they didn't find any of his blood on him. Please stop forgetting that there's multiple unknown male DNAs that we do not know.
It makes a lot of sense if the one hits him in the nose and then he makes sure that her clothes are what go in the creek. Throws all the clothes in the creek. He thinks he throws all the clothes in the creek or whatever. I don't know. That's also interesting.
I think Logan's DNA has been excluded from unknown DNA.
That's what I was getting at, is we don't know who was actually compared to the crime scene DNA because it was never said at trial. We don't know who was compared, except for Richard Allen.
Well, we know that there's untested hairs because they're waiting for new tech.
But we don't know who did, besides Richard Allen.
Okay.
If the third party stuff was allowed in, then maybe we would know if they excluded Ron Logan. Or Elvis, maybe. Carry on. T's good at this.
He left again and came back
later.
Came back later in evening. Search going on later in late hours.
Later on, late hours.
Tried to move oldest one to area not going to be
found.
Mm-hmm. Place where four-wheelers around go.
Yeah. I thought it was around. Then I thought it was always. That doesn't make sense.
Place where four-wheelers can't go. No. And something go. I don't know. Burned his clothes in burn pile. Hiking boots, gloves,
bag.
They're trying later. They tried to move the oldest one. An area not going to be found. Place where wheelers blink go. Burned his clothes in the burn pile. Hiking, walking boots, gloves, bag. Okay. Cold. Oh, could.
Honestly, I think this is a note like by him, or maybe a question that was asked of him by Reese.
Could soles of boots be located in burn pile?
Yeah.
Next morning, 2 more girls marched in door, asked to search on property.
The two other girls knocked on the door.
Other girls knocked on door, asked to search on property. He said no. Something felt weary.
Weird. Said no.
So he said no. He let them take.
No, he felt weird if he would say no. Like basically,
I felt weird if he would say no. He let them take off,
yeah.
got a hold of family member to get out of area.
Mm-hmm.
Did he leave the area on the 14th?
I was told, yeah. Angela would know better because she followed the Ron Logan stuff. Like I
Yeah.
think he went to like a grocery store.
No, he
But yes, he did.
went to a dump, or there's a photo of him with
That was the
some
13th.
family member.
The 13th at the transit center.
Oh, okay,
Yeah,
that's the third. Right.
But on the
yeah,
he's
but
saying he got out of there after these people came to search. But he said this is the
she
next
said,
morning. But people were asking him that night to search because remember when they interview him, he says that these girls stopped by and asked if they could search his property when he got home from the fish store. In that one interview.
no, I don't know that it was girls. I know that what's
I'm
his
almost
face
positive it was
said.
girls.
No, I have to look because I know that Angela told me he went somewhere.
I wonder where he if he actually left his house on the 14th after these girls came.
Let me look.
I've also always wondered about Pat Brown, and that was just a side theory, was because Pat Brown and Ron Logan were friends. Like if he told Pat Brown like kind of where to go, because Pat Brown wasn't a signed in searcher. He wasn't actually there to search. I mean, he was there to search, but he wasn't like official.
Now, the
Okay,
fish store, all that stuff. You guys were thinking of the places that he went
the
on the
13th.
13th. This is referring
Where
to
was Ron Logan when the girls' bodies were found? Where was Ron Logan on the 14th when the girls' bodies were found?
yeah, because this is referring to the next day on the 14th when they're found. They asked to search his property and he hightailed it out of there.
So first time he seen them from property. I don't know.
Yeah.
Something, etc. Enter.
Home something, etc. Guns, etc.
I have no fucking idea. It looks like guns, etc. Horse. I don't know. Guns, etc. During struggle, youngest girl scared, not or met.
Maybe
Happened.
scream.
Oh, screamed? No.
Maybe.
Maybe. Youngest girl screamed. Oh shit. Happened. Happened. Friend?
Friend continued to stand there. I don't know what that happened. Blank. Friend continued to stand there.
Friend. Head back on. I don't know what that is. Oh,
Neck
neck.
artery.
Okay, that makes sense. I could see that. Happened to friend stand there during struggle. Youngest girl not. Yeah, I don't know.
I think that's it for his writing.
Okay. The handwritten note signed by Reese Davis, dated June 21st. The same day First Sergeant Hansard interviewed him. The handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as for Sergeant's handwritten notes. His handwritten note about Ron Logan's confession to him says, Mr. Logan has made references to the killings in Delphi, Indiana. He told me he was the one who had killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking the blank. He grabbed the youngest girl to reassure her it was okay. However, they panicked. and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it took too far. So in addition to other details that fit the known facts, Ron Logan confessed to Reese Davis that he used box cutters to kill the girls. If instead of, for the first time at Mr. Allen's trial, Dr. Corse said 7 years earlier, said the girls could have been killed by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' murders. As it was, the FBI 2 months before Ron Logan's confession to Reese Davis had obtained a judicial finding of probable cause to search Ron Logan's property. Under the circumstances, Dr. Corse's trial testimony about a box cutter possibly being used to murder the girls makes Ron Logan's confession to Reese Davis newly discovered evidence that would either be admissible through Reese Davis or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at a retrial. Accordingly, the court should either vacate Mr. Allen's convictions or set the motion for a hearing.
Now,
Okay.
Michael, are you still here, Michael? Did we lose him?
He's still on, but I don't know if he might be doing something else. So I wanted to look at this, though, because I found this super interesting on this Reese Davis tip.
Yeah, I'm still here.
Okay, good. I want to ask you something, but also Angela answered me. She said store. This is on the 14th. Store with Nulf, the one with the W, Whaleman's. She's trying to remember the name. Called him around noon, picked him up around noon. But that was on the 14th. Or 13th.
Okay. Where was he on the 14th? Where's Chris Todd when I need him?
Oh, she said nope. When they got back to Ron's, the road was closed off because the girls had been found and police were asking drivers questions, etc. Nope. 13th was Aquarium World alone.
Okay, so where was he on the 14th?
14th was Nulf taking him to grocery store right before girls found. Grocery store called Wallman's or something.
So
Says
he
called
did.
him around.
He called his family member and had them come and take him somewhere.
Said called him around 9 a.m., picked him up around noon.
So that might actually be in. You know what? That actually might be in his.
I think it is.
I think it is. Now that you're saying it like that, I'm thinking that Nolf actually says that in his interview.
I'll have to look at I think it's in that
I'm almost
affidavit.
positive that Nolf says that in his interview.
But I wanted to ask Michael specifically with this Ron Logan thing where it says that it was admissible through Davis testimony or the other guy with the bad handwriting. Is that hearsay? If it's not hearsay, can you explain why it's not hearsay, why it would be admitted, why it would be admittable evidence? Let's say if they had been allowed to do the third party stuff, would it be considered hearsay?
So if Reese Davis is testifying, it's not hearsay because it's a statement against interest. Whatever the rule is, it's 804B3 is what I mentioned in there. Basically, it's the kind of statement, so it's excluded from the general hearsay rule on the theory that like people don't say things like this if they're not true. You don't say stuff like I killed somebody unless you actually killed somebody. You can argue about whether that's a good rule or not, but that's the rule. Now, if Reese Davis were so Ron Logan telling Reese Davis this, Reese Davis could testify personally about what Ron Logan told him, and it would not be excluded. What Ron Logan told him would not be excluded as hearsay.
Mm-hmm.
Now, if Hansard were to testify about what Reese Davis told him Ron Logan said, what Ron Logan said would be hearsay through Hansard. But those two cases are about the right to put on a defense. And on occasion, if you have hearsay that's reliable, and you can establish that it's reliable for any number of reasons. The Constitution kind of trumps the hearsay rule.
So,
And yeah, go ahead.
for example, what if this whole discussion between whatever the bad handwriting man's name is, and Davis, let's say that were recorded, would you be able to have the officer get in, let's say, video of him talking to Davis and Davis telling him all these things that Ron said? Or would you still have to have Davis?
You still have to have Davis.
Got it.
Now,
The,
if you had a deposition of shit,
can you depose an inmate? I think he dropped his phone in the toilet or something.
Maybe.
I heard, oh shit, and he sounded further away, and I feel like that's happened to me before.
Okay, so whenever he comes back, I'll let him finish saying what he was saying. So this tip comes in on 5/15/2017 with a confession on from Ron Logan, supposedly, right, according to Reese Davis. And they don't go and interview him for over a month. 5/15. And the interview that this first sergeant has is on June 21st. Sweet, Tammy. We're one step closer. So why did it take them over a month if they have this guy who's actually confessed to the crime?
Have you seen the Orion thing?
That's what I was just looking at.
Okay, so
Well, I went down there, but right here's the intake of 5/15 contacted the FBI public access line, to report a tip on the Delphi case. They don't actually follow up until June 21st.
Right. And then nobody does anything until after Richard Allen's arrested, and Kathy
Correct.
puts in there, she takes it upon herself to say, forget it, because nobody followed back up with Richie or Reese, and also Ron Logan's dead. She should have also said, and also we've already arrested Richard Allen.
The investigator is Shank Kamakathy.
Uh-huh.
So it does say that it's in regards to Jay Harper, on behalf of Jay Harper. So this is covered by Kathy Shank on behalf of Jay Harper on 5/9/2023. Why in the world is she doing that?
Good question.
And why is Jay Harper having her do that?
Like I said, I really wonder
What was Jay Harper's position in May of 2023?
ISP.
He was still ISP? But what was his position? Do you know? Do you know what his rank is?
Hold on.
There's Michael. He made it back. I figured Luke's messing with your Wi-Fi.
hey, Dick, I keep forgetting how StreamYard drains the phone dies.
Oh yeah. Yeah, but what was his position? Hey Arnhem, what was his? Was lieutenant, sergeant? Does anybody know what he was?
Who?
Jay Harper in 2023.
I have no idea.
Okay. So Kathy Shank is just saying nope. Lead is discontinued due to no follow-up with Reese Davis, and Ron Logan passed away, so it doesn't really matter.
In 2025, there's a thing from our favorite Karen at Carroll County Comet that says ISP detective Jay Harper interviewed Kathy Allen on the 26th of October in 2022.
Oh yeah, Jay
That,
Harper was the one who interviewed her.
so that just says detective.
Okay, maybe he's just okay, just detective. That's what Catastrophe said too. Just detective. Okay. Well, that's interesting. Lead is discontinued as of 1/6/23. Due to
Because
no follow-up.
I wonder how many times leads throughout were discontinued because no one followed up and they arrested Richard Allen or said person died. Like, I'm sure Ron Logan ain't the only one that died.
But I'm still confused. There is follow-up, though.
Just one.
Right. And then nothing ever happens about that.
Right. I mean, as far as we can see, as far as what Kathy's saying.
And I don't understand why it takes over a month to go interview this guy who's saying that there's a confession that somewhat matches the crime scene.
Well, they maybe had a bunch of things to do, number one. Number two,
The number one thing they're there to do is to solve the fucking murder of the girls.
well, but they were both in prison, so it's not like maybe they were looking up other things. They were also in that time doing search warrants on Ron Logan's house. Like maybe they were trying to get more information. But also, at that time, whatever, I would be super curious to know whatever particular things they were keeping in mind when it came to things only the killer would know, so that they knew when they had a false confession and when they didn't, because according to them, they didn't know shit about the van going down the road until 2024, so that wasn't it. They didn't know shit about this box cutter thing because Cora didn't say that until 2024 at the trial.
Yep.
So I don't know what particular things they were looking out for, but it's not like that would have threw up a red flag because Cora had said it might have been box cutter. You know what I'm saying? I really do wonder what those things were that they were, the sticks, maybe, that one of them was clothed and one of them wasn't. I don't know.
So it's also interesting that he doesn't ask for like any leniency on his sentence or any consideration for himself on this. Said Reese wants nothing from this but justice for the girl. Somebody asked if he's still alive. As far as I know, he's still alive. He was requested to be transported for trial.
Mm-hmm. But then she didn't let any of the third party stuff in, so obviously he wasn't necessary along with the rest of them.
Okay.
But as for this, like, I've seen people say, why didn't the defense bring this up at trial if they knew about it or whatever? We don't know if we do know that she granted the motion that Nick filed to exclude this, but we don't know if they tried to renew it like at a sidebar, because we don't know anything about the sidebars. No one could hear, and her say no, in which case then they wouldn't be able to.
Well, they brought up that they should be able to bring in the third party during the trial, right? And they file a motion and she never responded to it during trial.
Well, that was about the sticks. That was about the interpretation of the sticks, because what's his face said that it was covering them or whatever.
Right.
Camouflage or whatever he said.
Yeah, that they were allowed to bring in their theory, but the defense couldn't bring in theirs.
To their interpretation of the crime scene.
Right. Okay. Go back over here. Okay, Michael. So in this, with this Ron Logan stuff, tell me legally how this becomes relevant now when they requested to have Ron Logan as part of their third party and were denied allowing him into the trial.
Well, I mean, the argument goes that once court testifies that it's box cutters, I mean, that's what Nick McLean said. Detail only the killer would know. So it's past cast the testimony in a whole new light. Can cast the confession in a whole new light. So in that sense, it's newly discovered evidence. I mean, Core, if they had Core's opinion earlier, maybe they'd been able to do something with it. But Core comes up with the box cutter thing for the first time at trial, and so in that sense, it's newly discovered evidence. And again, it's an argument. And part of the point of this also is to get this. You don't. I don't know what was preserved for appeal, what offers to prove were made. I mean, third party stuff was, but look, anything you can get in front of the Court of Appeal, assuming Gold just stands denied on it all, right?
Right.
Anything you can get on the Court of Appeals that makes Rick look more innocent, gives human beings up there in black robes more reason to reverse. And when they, and this plays into the third party stuff, and it's actually really detailed and graphic illustration of stuff that was, even if you don't call it newly discovered evidence, it was stuff that was kept out. And so I've been saying this is what you call stuffing the appellate turkey. And, 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 and not to no point. I mean, it's a good claim on its face. I mean, this isn't just idle stuff that's in. Gull could hold a hearing and grant relief on this.
Oh, Michael.
I'm saying could.
I think I'd shit a brick.
Well, I said earlier on Bob's. I mean, if I were a pro-prosecution judge, I would seriously consider setting this for a hearing and give the state its opportunity. At a minimum, I'd ask for a response from the plaintiff.
Yeah.
You don't think that she'll just send out an email to all of the attorneys and just give them like a quote unquote idea of what to put in a response?
Well, she's not supposed to do that.
Yeah, well, wouldn't be the first time. Okay, so
She'll hit
anything
Nick
else?
with another, as you know, I know the rules.
I know all the rules about third party.
Well, I mean, that's actually, one of my biggest hopes for the appeal. Depending on how it was preserved, she made a real mistake. So if a judge just says denied, right, or overruled and doesn't give any reasons, an appellate court is going to find any reason it can to say that was okay. But she denied the third party stuff, and I think it was after they renewed it so they wanted to do after somebody testified that the crime scene might be an undoing. They argued that opened the door to the Odinist stuff, and with the Odinist stuff you have third party guilt, and she denied it, saying there was no nexus because there was no DNA. And that's a legal error. And so the standard for evidentiary rulings by judges on the standard of review is an so-called abuse of discretion, which is a very low standard. I mean, a very high standard. The judge has to do a lot to abuse their discretion. But basically, you got to do one of two things. You've either got to make some absolutely crazy factual finding, or you have to make an error of law. Well, in saying there's no nexus because there's no DNA, she opened her mouth, made a mistake. Even if that's if that's what she was thinking, she still shouldn't have said it, but she did, and that's an error of law. And I think that is quite possibly reversible error, but that's going to be subject to harmless error analysis. And, the Court of Appeals, we've got these so-called confessions. And, it's very easy for a court to say, yeah, that was a mistake, but there are these confessions, so the error was harmless.
Is there no legal way, though, to tie in the fact that there is all these confessions from these other people? Like, to tie that into the fact that she's saying there's no nexus because of there being no DNA. So she says, okay, they say, okay, well, it's a harmless error, but it's like, because of these confessions, that can't you turn around legally? Isn't there a way to go like, well, we have these confessions? Do you know what I mean?
Well, I have always thought that the defense, again, they know their jobs and they know what they were doing. But well, let me put it this way: I don't know that I think this is something defense should have done, but I think it would have been a good thing to do. And that once the third-party guilt stuff was excluded, because in unverified pleadings, Nick was coming and saying all these people are cleared, blah blah blah. So I think the thing that would have been really interesting to do is not just argue that Rick's confession is false because he'd been driven nuts in prison and horribly mistreated, but in order to tell the jury that people do make false confessions, I would have brought all those confessions in and said, state says all these people were cleared. Guess what? They have all confessed. They must be false confessions. What's that question? I can't read it on my screen. Can the
It says,
defense
can the
enter
defense enter all? Yeah.
the appellate court to see the context and psychosis?
Because
There
that
was
was
an argument.
that they couldn't enter the calls and any of his other confessions because if they put it in, it's hearsay. They have to put Rick on the stand to put it in, which
Yeah, something like that. And they made an argument about completeness. And there is a doctrine of completeness that you should be able to get stuff in. And I think Brad was talking about that on Bob's Live tonight.
Mhm. Yeah, about that
But
first call to his dad, to Rick's dad.
yeah, but look, I don't know. I don't know that they made an offer to prove. I don't know if they said, okay, take the jury out. We're going to put this on. So I don't know. I don't know that it's in the record, and I don't know if it's
I
preserved for appeal.
I have heard several instances where there was mention of them making offers to prove, and she did not allow it. Like, I don't think she allowed any offers to prove at all. Because remember, she
I
did that order in the beginning, like before it started, where she said that she would consider allowing them to do offers to prove during trial.
Yeah, where they asked her if instead of doing offer to prove on all of the testimony from the hearings, if she would just automatically put that in the record instead of having to waste the time to send the jury out and do them all again.
Well,
And then
she
they
said
would do
that.
any offer of proof later. And then when they do, there is something that happens at trial, and I'm not going to be able to quote it exactly, but there's something where they try to do an offer of proof on third party, and she tells them at trial, I understand what you're saying, but I already told you there's no
Yes.
nexus.
Yes. That. Yep.
So one thing they did that was really weird, but one thing they did was after the state had finished its case, so the evidence is over. They made an offer to prove on Elvis Fields' confession.
Yeah, because he stuck in a subpoena.
And Gall said, "Well, what would he say?" And I think Andy said, "Well, we don't know. That's why we need him to testify." And that's not an offer to prove. I mean, an offer to prove means you got to get up there, stand up there, and say, basically, he'd say exactly what was in his confession. and you tell the court what I believe the witness would say, X, Y, and Z. You don't, and you don't do it after the state's rested. After the state's rested, you do it in your own damn case. I'm not the trial lawyer. Andy absolutely knows what he's doing. Brad and Jennifer, unbelievably amazing trial lawyers too, so they know what they're doing. As I'm looking at it from the outside, I didn't get it.
I remember that they requested that she issue a warrant for Elvis Fields because he had been subpoenaed and was basically trying to not be served to show up. And she said no. Basically that she had.
And that might be that might be an issue for the appeal too. I don't know. It's going to be a big job for Mark and Stacy to sort it all out.
Okay, so let's talk about the last part of this then, which is the affidavit of Stacey Eldridge, where she states that the dirt or the water damage to the phone could not have caused the auxiliary jack on Libby's phone to log wired headphone plugged in and wired headphones unplugged. And her expert opinion is newly discovered evidence that would probably produce a different result at a new trial. So at trial, as many of us already know that, we had the whole Google search. We have a Google expert in Cecil. At trial, Mr. Allen introduced evidence through the testimony of Stacey Eldridge, a digital and mobile forensics expert, that someone plugged wired headphones into the auxiliary jack of Libby's phone at 5:44 p.m. on the 13th and unplugged them at 10:32 on the same day. To counter this, the state offered the results of a seat of the pants Google search by, I just love these. You can just go through and highlight all those fun, what you call them. They're not euphemisms, but what's the right word? Google search by First Sergeant Cecil, the state's phone expert. According to First Sergeant Cecil, the Google hearsay told him, in his expert opinion, the log on Libby's cell phone showing wired headphones were plugged in to the auxiliary jack at 5:44 on the 13th and unplugged at 10:32 that same day could have been caused by dirt or water damage to Libby's cell phone. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should read Miss Eldridge's affidavit, Exhibit 5, in its entirety, but the short version of Miss Eldridge's actual expert opinion is that nothing in the data on Libby's phone indicated there had been water damage. None of the reports or the extractions related to Libby's phone created by law enforcement officers reflect dirt or water damage to the phone. Photographs of Libby's phone taken by ISP did not show the phone to be wet, dirty, or covered by debris. Miss Eldridge is unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6S would cause the phone to inaccurately log wired headphones in or wired headphones out. According to the Apple Health data on LG's iPhone 6S, the phone stopped moving at 2:32 on February 13th. At trial, the state contended that Libby and Abby died close to that time, and Abby hid the phone under her body before she died. The state also provided testimony by former Delphi Police Chief Steve Mullen and ISP Lieutenant Jerry Holman that there was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbaugh on 300 North at approximately 3:50 on the 13th. If Miss Eldridge's actual expert opinion that wired headphones were plugged into LG's auxiliary port at 5:44 and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling LG's phone multiple times long after the state contended Mr. Allen left the scene before 4 p.m. on February 13th. Miss Eldridge's opinion that dirt or water could not have caused LG's phone to log wired headphones being plugged into and unplugged from the phone on the 13th exculpates, God, I hate that fucking word, Mr. Allen, and would probably produce a different result at a new trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for hearing. So I have a couple questions here. So one of the things stated in here is that they didn't have the defense doesn't have the opportunity to counter that. Couldn't they have called her back to the stand?
No,
Why?
they were in rebuttal. Their case in chief was done.
They hadn't rested yet.
Yeah, huh? This was during Nick's rebuttal.
No, Cecil comes back up.
In
No,
That's
I
when
Nick's
think
Cecil
rebuttal.
comes up after break. It's when she calls him up. She calls him
yeah,
up there.
I think the defense called Cecil,
Yeah.
and I think
Yes.
I think the answer is, look, again, it's just an argument. Let the state counter. Let the state counter it. The argument is, Stacey Eldridge was an expert. She was expensive, and they released her. And then Cecil, they put Cecil on, and he comes up with a damn Google search, and they can't get Stacey Eldridge back. Now, the state can argue, well, they could have asked for a continuance, stop the presses. I don't know. I mean, I look like Bob's in the chat. I think they made a hearsay objection to the Google search stuff.
They did.
So
She
that's
said it
preserved.
wasn't.
Yeah, that's really, Andrea Burkhart said that she'd seen lot, bad judging in a lot of cases, but nothing like this. And the idea that Cecil's Google search results are not hearsay as expert opinion is mind-boggling. Just so obviously hearsay that.
But she did say that Westcott, I think that's her name, the doctor, that her testimony was totem pole hearsay because she was going off medical records of information that Richard Allen had told other providers.
And that's wrong too, because stuff that Rick Allen had told her was what she based her opinion on. They're not being offered for the truth. It's just, I mean, I saw this in a double LWOT. So there were two defendants in an LWOT trial, and the psychologist involved who examined one of the defendants wanted to base his opinion and tell the jury about things the defendant had told him. And there was hearsay objection from the state. The judge sustained it. That's just not the way it works. You're allowed, you have experts, and they're allowed to tell the jury what they base their opinions on, and then the jury can evaluate, what weight to give to that expert opinion based on what they based on what they base their opinions on. The Indiana judges have a really, really bad understanding of hearsay. No, I mean, I see it all the time, and lawyers too, for that matter.
So I guess so my question still is, could the defense not have just called Eldridge back to the stand and said, okay, or is it just kind of like
She may have been on a plane back to Oklahoma.
Yeah, she wasn't from there.
I know, but this is all happening the same time. She's on the stand. They take a 15-minute break. Cecil's on the stand. Bunner's on the stand. Like, it's back to back. So that's what I'm just trying to figure out, like, legally, like, how much weight does this part hold?
Look, it gets the expert. It's a plausible argument, but what? It also is now, there is now an expert opinion in the record for the Court of Appeal to counter the Google opinion.
So regardless, they didn't bring her back to testify, but now
Right.
they have what she would have said, whereas they didn't before.
Great.
And having this argument in there, depending on how it's treated by the court, may set up other claims later.
Is there anything, like, legally about, like, that she would have to go, I mean, like time wise, like because she'd have to go and actually like see if there's anything scientific about that, like to counter that? Is there anything when it comes to experts like that? You know what I mean? Like time wise, or no?
I don't know. I'm not sure I understand the question.
For her to be able to like show scientific proof instead of a Google search that it's impossible for that phone to have had water damage or dirt. You see what I mean? Like,
Well, I mean, she comes pretty close to that. I mean, there's nothing in any of the records related to the phone showing water or dirt. She doesn't know anything about any research that shows that the headphone data would be created by that. So she comes pretty close to it.
okay.
So basically, she was probably asked if she could be released from her subpoena, and if Jennifer didn't think she was going to have any more questions for her, and she said yes,
Right. I don't
then
know.
nothing could compel her to come back.
Okay, so now that this is all filed, what should we be expecting on the legal side of things to be next?
Well, either a response from McClellan or stamp denied, and the dark horse in the race, the very long shot is a hearing.
And what should we be expecting, like with the appellate attorneys? I know you can't speak for them, but like just from your experience.
I think once the motion to correct error is denied or deemed denied, they'll file a notice of appeal within 30 days after that happening. The appeal will be on.
Unless they get extensions. Like, realistically, how long could we be waiting
No,
for?
no, 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 no. They're not going to get extensions for the notice of appeal.
They have 30 days to file the notice of appeal.
From the denial of the motion to correct error.
But the notice of appeal is it's not specific, right? It just says we're going to file an appeal.
Yeah. Uh-huh.
So the
Yeah, and then
actual.
you'll have to go to the appellate rules. I mean, Kara could tell you off the top of her head what the deadlines are. There's a deadline for the clerk's record. There's a deadline for the transcript, and then the briefs. The deadline for the briefs are, I think, 30 days after the transcript filed, and so I think they'll, this brief isn't going to be filed until mid to the end of summer, is my guess.
That's basically what I was getting at. Is no informational file, like nothing that's going to have information or arguments in it will happen until they file the appeal. That could be however long you just said.
Yeah, pretty much. But the good news is that a few people out here are working on how to start the post conviction investigation now.
Okay.
Good.
So there's a few different facets that are happening at the same time.
Yeah, I mean, my concern's always been that this case is already 8 years old. Like, evidence is going to start disappearing. Witnesses are going. I mean, there are some old people involved, very old people need to be talked to, and yeah, and now with the conviction as well, maybe there are people who are more willing to talk, who actually have a conscience. And the other thing is, it'll be really interesting. I'm hoping that some jurors will see this motion to correct error and be maybe pissed off that they about the van evidence, and maybe they'll start talking. Who knows? But look, do what you can and see what happens. Bob's in the chat. Tell me if I'm wrong, Bob. You're the trial lawyer, not me. But I have a couple or three things at the top of my list of what need to be investigated immediately.
Anything you can share with us?
No.
That was a quick answer, man.
I know, right? Hey,
Quick.
it was worth a shot. It was worth a shot. Bob says you're not wrong, Michael. Okay, so is there anything else that we need to talk about from the filings? I have a link to the court TV interview, so I was going to play that, but I want to make sure that you guys, anything else that you guys want to talk about when it comes to this, we cover it first.
No, what
Oh,
court
no, I'm pulling out the popcorn for the court TV stuff.
I heard Bob murked somebody on court TV.
I don't know. So it's like it's still like loading up.
What does mean? What does murk mean?
You should type it into what's that thing that tells you all the slang? Urban Dictionary. Ooh, if we could, I would like to have that in a filing.
A clip of you storming through the courtroom, looking at a camera.
All unfolded.
And
discovered that later, which probably what he did, that he tried to.
Oh, he went on court TV? I had no idea.
I'm just trying to get it to actually play.
What the jury heard. Yeah, they certainly were aware that he.
Can you guys even hear that?
Yes, I'm just confused.
What? Bob was on court TV while we were live.
But
Bob's
that's
literally
Brad
been in
Rosie.
his desk chair all day today. He has not left that fucking chair.
But that's Rosie.
This is Rosie. Yeah.
He went on court TV too?
Yes.
Oh, okay.
So, like I said, I'm just trying to get it to load
$300 off
correctly,
any-
and it doesn't seem to want to do that because it's on replay on the app instead of on YouTube. It won't be out on YouTube until like tomorrow.
Oh, so I definitely need you to play
If I can't
it.
get the whole thing to play tonight, then I'll play the whole thing tomorrow with commentary so we don't get in trouble. So.
To be a nightmare.
You guys can hear it though? I just want to make sure you guys can hear it. Did you say yes?
Yes.
Okay, let's see what happens.
Are costly, but with
Does
endurance,
not want to let me
you
go
could
back because it wants me to listen to this stupid app.
repair again.
They covered a 14. Wait, visit endurancewarranty.com
Yeah,
for
the ad
$300 off any plan.
Oh, we'll get struck for that.
Yeah. Let me let the ads go.
We should make up our own ad. What do you think he's saying? Oh my gosh.
Let's see. Let's say he just has commercials blocked. Yeah, I know. I don't know. I'm trying to get it to load correctly. I hate when I have to try to do things on court TV on the app.
Live.
Yeah,
On
it
our
sucks.
website.
So just bear with me for a hot minute. We'll see what we can do.
And if you go out of it, it automatically will start the
Which is probably
ad
actually
all
good
over.
at this point. I may do that.
What?
Go out of it and start over.
It never lets me rewind the live TV.
Well, it's not live. It's already done. So it's just replaying the last live. You see what I mean?
Yeah. It is 1 o'clock and I'm scared to look outside.
Oh, you got to see how much snow you got.
No, thank you.
All right, let's see. See? It doesn't want to let me have it.
Rude.
Right? This VPIs aren't released until tomorrow on YouTube.
Surely Courtney screen recorded this, or
Well, normally I'll just let me go back and watch it.
Radar said I had to exit once and restart.
to go back and watch it?
I reckon. Boners pay the bills.
Doesn't want me to go do that now. Hold on. Good night, Richard. We'll try it again. Like I said, otherwise we'll just watch it tomorrow. If we can't get it to do what I want it to do.
Just so you know, we don't see whatever you're doing.
That's fine. Yeah, it's on my other screen. I was trying to open up a separate window
Mm-hmm.
to let me play it. Because it was letting me play it, and then I went out of it, and now it's not even letting me go back to that video.
Yeah, it was letting you play it, because I did see it.
Yeah. You know what? I will play. I have another clip to play, though, from the news that I thought was interesting, too, based on just the filings. So I'll play that while I try to figure this one out. I don't know if you guys saw this, but they always talk to, they have like their attorney that is, what do you call it, like collaborates with them, or they collaborate with.
Tonight we have new information on the Delphi double murders case. The defense team.
You guys hear that okay?
Yes.
I'll play this while I try to figure out this court TV thing.
For convicted killer Richard Allen is raising new questions about multiple items, including the state's timeline of the murders. Allen was convicted in the murders of Abby Williams and Libby German in November.
Now his attorneys argue that conviction should be vacated. Fox 59's Eric Graves has been reading through these documents for us today and now joins us here in the studio. And Eric, you talk with some of these legal experts who say these motions will bring this case likely back to court.
That's what they expect. This is the 24-page motion of errors. In it, Richard Allen's defense team outlines
Motion of errors
could have changed the outcome of his trial. Allen's attorneys are hoping this can get his conviction vacated. Richard Allen is currently serving 130 years in prison for the killings of Abby Williams and Libby German near the Monon High Bridge in 2017. Allen's attorneys have filed new motions calling for his conviction to be vacated. Indianapolis defense attorney John Tompkins isn't affiliated with the case, but gave his expertise on the motion of errors filed Tuesday by Allen's defense attorneys. They say Allen's Sixth Amendment right was violated when his attorney was not present at an initial hearing in 2022. The attorneys say this email is evidence the state knew Allen had representation.
It's clearly not appropriate when you know a person is represented to proceed without their attorney present.
The motion also includes new video disputing the state's murder timeline presented in court. The defense says this video shows a white van arriving on the day of the murders near the crime scene at 2:45 p.m. Zoomed in, you can see the van. In court, the state told the jury the white van arrived around 2:30, spooking Allen just before he killed the girls. Tompkins says the times not lining up could be a major blow to the state.
I think any judge would have to give very serious consideration to reversing the conviction because that was the core of their theory of the case.
Perhaps even worse for the state is if the prosecution knew part of their core story was false.
If they acted intentionally or knowingly, then you would get potentially reversal with no new trial.
In the motion, the defense also presented another suspect for the crime and an apparent confession not yet heard by the public. These notes were taken by a state police investigator from an interview with an inmate who said Ron Logan confessed to the killings while he was in prison. Logan owned the property where Abby and Libby's bodies were found. He gave investigators a phony alibi, and his home was searched by the FBI in the months after the killing. The pathologist who performed the autopsy on the victim said in court a box cutter could have been used in the killings, which is what Logan said he used to murder the girls in his 2017 confession.
They've tied it to actual evidence that was presented by the state at trial and arguably should have opened the door to them being able to get some of these other suspects and information about the other suspects in front of that jury.
I asked Tompkins if he thinks this could put Richard Allen's very recent conviction and sentence in hot water. He says it deserves a hearing where the defense could expand on these points and the state can counter the claims made or clarify them. Coming up later tonight, we'll have more on the new evidence presented pointing to Ron Logan as the Delphi killer. In the studio, Eric Graves, Fox 59 News.
All right, Eric.
I thought that was interesting. Even though they don't know how to say it correctly.
They still want to break my phone. Like, it's the title. All you have to do is read the title of the motion. It's in your hands.
It won't let me go back now to that at all. Even though I was in it, it won't let me go back to it.
Motion of errors.
So I don't think we're going to watch the court TV thing tonight like I thought we could. It just does not want me to watch it on there.
Rude.
You know, I got to say that news report, I mean, that's really the first really pro-defense news report I've seen in a while.
I agree, but that attorney that they talk to always seems to be very pro-defense. I don't want to say pro-defense, but he's like, oh, he's typically always looking at it like, yeah, I mean, they're making really good points here.
Look, you know, we're probably not going to get a hearing from Gull, but he's right about it. I mean, what he was saying was really right down the middle of the law. I mean, it deserves a hearing.
So this is the second part where they said they'd be back later to talk about the Ron Logan stuff. So I'll play that for you too.
Wait, I want to hear this, but I want to ask Michael real quick. What was the part that he was saying towards the end that cut him off where it said if they could prove something or other, then
It was done
that would mean
intentionally.
yeah, that he could get like a conviction without a new trial or whatever he said. Did you catch what he said?
Yeah, I think he was saying. I think he was saying that. I think it was based on the core stuff in Reese Davis confession. Might get, or maybe it was the knowing use of the false evidence, actually, but about Weber, that you could get a retrial barred, and I think what he's thinking is that. Look, I don't think they could try. I don't think if it's reversed, I think they'd have a really hard time retrying him.
I see.
But if the state knowingly used false evidence to get the conviction, yeah, retrial might be barred. It's an extreme sanction, but it's possible. I mean, I wouldn't get it. You know, people have been saying, "Oh, I've been saying the appeal is going to be a slam dunk," and you know, I'm not going to say the appeal is going to be a slam dunk, and I'm not going to say that it's likely that you know a retrial would be barred. I know how I'd prosecute the case if I absolutely had to prosecute Rick Allen for this. I know exactly how I'd do it, and I ain't saying.
Yeah, don't do that because you know he walked it.
What are we saying?
He's innocent. I mean, I wouldn't do it if I were a prosecutor, but if I were put in the position of having to do, I mean, let me put it this way. McClelland put on the hardest possible case for himself.
Oh, I know where we're going with this, and I agree.
Yeah.
That's also how I would prosecute it, but he's a dummy, so don't give him any help for trial too.
No.
Developing news in the Delphi Murders case. Attorneys for convicted killer Richard Allen have filed new motions to try and clear their client's name. A jury convicted Allen in November of killing Abby Williams and Libby German in 2017. Now, the motion of errors filed today questions the timeline for these murders, with new video placing the white van that spooked Richard Allen before the murders at the crime scene 15 minutes after the murders. Now, attorneys also claim that Allen's Sixth Amendment rights were violated when his attorneys weren't present at an initial hearing in 2022. And the defense is also disputing evidence from Libby's cell phone after testimony claimed the state found someone was plugged into Libby's phone after the murder and that they didn't bring it to jurors. But the biggest bombshell revealed this morning, another jailhouse confession for somebody who attorneys claim was a prime suspect from the very start.
And Dan, all of that really revolves around Ron Logan, the man who owns the property where the girls' bodies were found. And this evening, Fox 59's Max Lewis breaks down what was allegedly said inside of that jail cell in 2017.
The defense called it newly discovered evidence that is so significant and entitles Richard Allen to a new trial. It's a confession to the killings of Abby Williams and Libby German made by Ron Logan, who owned the property where the girls' bodies were found.
The confession apparently took place inside the Newcastle Correctional Facility, where Logan was serving his sentence for a probation violation. It's there that he got to talking with another inmate in his cell block, Ricky Davis. In a letter signed by Davis in June 2017, he recounted Logan's confession, writing, quote, "He told me he was the one who killed those girls, that it got out of hand. He walked with them in the woods to his property. The girls wanted to turn back and said something about calling the police." Logan apparently went on to say that he, quote, "grabbed the youngest girl to reassure her it was okay. However, they panicked and he also panicked." Logan indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was taken too far. At the time of that supposed confession, the fact that the girls' throats had been slit and that a box cutter was the likely murder weapon were not public knowledge. In fact, it wasn't until the trial late last year that the forensic pathologist who performed the autopsies testified that a box cutter was the likely murder weapon.
Now, looking back, they're able to say, well, with that box cutter information, that opened the door. Once they put box cutter and they had a suspect who confessed to using a box cutter, we definitely should have been able to get into at least this other suspect.
However, Judge Fran Gull ruled that the defense team could not put forward any theories about other potential suspects. In the early days of the Delphi investigation, Logan was a prime suspect, so much so that the FBI was able to secure a search warrant for his home. It's unclear if they ever found anything connecting him to the murders. But Allen's attorneys say that confession and the details in it exculpates Mr. Allen and would probably produce a different result at a retrial.
Logan died of COVID back in 2022. The prosecution has yet to respond to these claims or any of the others made in these filings. Our legal expert told us that right now it is too soon to tell how or even if this will affect Richard Allen's conviction for the murders. In the newsroom, I'm Max Lewis, Fox 59 News.
All right, so there was part 2 of that one. So I think that what we were watching with Rosie was the very end of the replay. And so that's why it's not letting me go back. So if you guys didn't get to catch it on the crime or the Court TV app today, then they'll be on YouTube tomorrow. I'll be live tomorrow because we're going to talk about Nick's interview, and we'll talk about the Court TV episode from tonight and anything else that you guys want to talk about.
I think the Gremlins interviewed both Nick and Liggett. Yeah.
Yes. I said I'm not going to listen until I'll just read it when you give me the transcript. Or I'll download the transcript myself. I'm not going to listen to their shit. So. Yeah, so I know that you guys, some of you guys were waiting so that we could watch that together, but we're not going to be able to watch it tonight. So we'll watch it tomorrow. Maybe Bob will give you guys a little rundown in chat real quick of how much fun he had on Court TV. I can't wait to see Vinny's faces. Those are my favorite.
I really hope, I have high hopes for his faces after this. Like, I'm hoping they're equivalent to or better than
his Doug Carter face.
Yes. Yes, I have high hopes.
Oh, that was the best. I love Vinny. Okay. Well, do you guys have anything else that you guys want to add? Otherwise, I got nothing else then until tomorrow.
No, it's 1:15. I'm tired.
Yeah, I think the only thing I want to add is,
do you have?
Huh?
the only thing I want to add is this is an incredible group effort getting this done, and there were 12 or 14 people at least involved, and all of them did necessary things that are valuable. it was a great group, and I think not saying anything wins, but I think we came up with some good stuff and put it together and got it in, and we'll see what happens.
See what happens. I mean, there's some clear-cut things in there that are like, wait a minute. There's evidence that actually backs this up. I'll be surprised if Nick responds.
I don't know, man. If I'm looking pre-trial, he didn't really ever seem to care to like want to dispute anything they said. Like, I think the most explanation we got was from the Franks when he basically just said this was colorful and whatever he said. And mostly, what did he say? Basically that some things weren't true. That's the most that we get. I can't see him putting much effort into this. He's too busy doing interviews. Yeah, he just repasted the PCA over and over again. That is really what he did.
Yeah, so
Not
I have
completely
not listened to the interviews on that podcast. I have not listened to Nick, so we're going to watch that together. You guys, I know I've watched it. Probably most of you guys have watched it, but I have not watched the interview with Nick besides a couple clips that I caught on Excited Utterances channel. And then obviously I have not watched the court TV. So tomorrow we'll do that and hang out and see what comes up. So, but no, I mean, Michael, I think you guys, I mean, I know that you, like you said, there's a ton of people that are working on this behind the scenes. And I mean, I think for the majority of us, at least here, we're just looking for the truth. So I don't think the state doesn't want to give it to us. So I don't know if at this point the defense, the appellate attorneys, and anybody who can, I think that's the only way we're going to figure out what the fudge happened here.
Well, I think the way we're going to figure out what the fudge happened here is by getting the post-conviction investigation going right away.
I agree at this point. Because I don't think it's going to be enough just to get, like... Am I wrong for feeling like... And I think I said this to somebody today or sometime recently, that it really does feel like at this point, if they don't solve it, then it's never going to matter for Richard Allen. Like, in terms of, even if he got a new trial, that unless they were able to present everything and, like, prove not just that he didn't do it, but that somebody did do it and who, it feels kind of hopeless.
Well, I don't know about hopeless, but I've said even before trial that I thought there was a high probability that the only way the defense really has to solve the crime for law enforcement apparently has to manage.
The juror made me more concerned. Once I heard her, I kind of was like, okay, so basically it seems as though unless you can find, the bridge guy, I don't know. I didn't like that interview. I'm sorry. Out of all of them, I think that one bothered me the most.
I think knowing that that's the people on the jury.
Yeah.
Like, that's your first representative of who was on this jury. That's a tough pill to swallow. If she had been the fifth person that had come out or done a group interview, I don't think anybody would have cared as much about what she had to say.
Yeah, but none of them have jumped. Like, me personally, if I was on the jury after I heard that, like, I'd be jumping to speak for myself. You know what I mean? Even if I felt the same, I would still want to speak for myself.
Yeah, Brad Rosie mentioned federal court and his live with Bob, and there have been a number of questions about writs of habeas corpus in the chat tonight, and I got to tell people, you all need to forget about that, because a habeas case for Rick Allen is, 8 years down the road.
Okay, well, that's interesting to know. People were bringing it up earlier, but we were in the middle of talking about other stuff, so I didn't actually ask. But I didn't think about it being that it would be 8 years down the road. So that's not the focus right now, obviously.
Isn't that once you've exhausted like everything else?
Yeah, pretty much, unless you've got a claim that is so good that you're willing to go to federal court before you've finished everything else.
And then do you waive all the other things?
Yeah, because you only get to go once.
Yeah.
So
All right,
you
you
have
guys.
to,
Well,
you have to figure the appeal won't be decided until probably a year from March, earliest. If he loses that, it's going to be another 4 years at least for the post-conviction case. And after that, it would be probably a couple or 3 years of litigating a federal case. I mean, he wouldn't get any. I mean, you know, it's 7 to 10 years before he could possibly get relief in federal court. So, you know, just people should stop asking about it, and we need to get on the post-conviction case and do whatever we can to help the appellate lawyers.
you heard it. Don't worry about the habeas stuff. Worry about the post-conviction stuff.
Thanks, T. It's always fun.
Michael, I appreciate you so much. I mean, there's just not enough words to tell you. Thank you for coming up and walking us through it and keeping us on track. Sleuthy and I, you know, we go off the rails sometimes.
Yeah. But he hangs in there.
He does. I think he just like does other stuff while we're just rambling.
I think so too.
He's just like, I'll just go do the dishes right now while they do whatever the hell they're doing.
That's okay.
We appreciate you, Michael. Thank you. Bob, you did amazing today. You're always amazing, but thank you for popping in here. I know you probably need to go to bed because your chair has your aspirin in it from today. You lived in it the entire day. Thank you for your amazing coverage on all the things. So, and Sleuthy, I love you. Thank you for just being a brilliant person that just likes to talk to me and walk me through things and is always there when I need you. So I love you guys. Thank you guys for being here. I know that you guys have 1,000 other places that you could spend your time, yet you spend your time here with us, and we absolutely appreciate it. We'll see you tomorrow. Have a good one.
Love you. Love you. Bye. Bye.
Love you. Bye.
Bye.
Bye.